And I hope we are all fine from our holiday yesterday, our Freedom Day. It's our last day today on the oral presentation in terms of COIDA. We will then be assisted by the co-host. I have been informed, has been reported that Mr. Sakaza has gone home for an urgent family responsibility. I'm not quite sure if he is then going to be able to log in. They will indicate whom is then going to, in terms of the staff, whom is then going to tell us who is here, who is not here today in terms of members. And the presenters, who's then going to be the first. But Mr. Sakaza did report to me that he has then requested the content advisor. I hope it is he is in. Honorable, I'm sorry, Mr. Ngobo, and the secretary support staff, Portia. Then they are the ones that are then going to be dealing with this. So just want to get an indication from them who is then going to then be able to do in the event that Mr. Sakaza is unable, who is then going to assist us.
Chair, good morning, Chair. I can start the meeting to you, and then Mr. Ngcobo is going to take over.
Okay, can you take us through the roll call?
Yes, Honorable Chair.
Over to you, Mr. Sakaza.
Okay, good morning, Chairperson. Good morning, the members. Chairperson, we've got today, as I look at the roll call here in front of me, I've got Chairperson, Honorable Chair, Honorable Dunjo. I've got Honorable Ndabe, Honorable Zuma, Honorable Bagram, Honorable Kado, Honorable Yinana, Honorable Mkondo, Honorable Ngcobo, Honorable Daniel, Chair, from the Portfolio Committee so far, Chair. And then, Chair, from the presenters, we've got today 6 groups. The first one will start is a Relay Emergency Medical Services, which will be followed by Hospital Association of South Africa, which will be followed by Richard Spoor, which will be followed by Workers' Compensation Assistance, which will be followed by Wits School of Governance, and the last one would be Injured Workers Action Group. They will introduce themselves as the first one will be Relay, already logged in, so they can start after you, the Chair. I don't know from the department, Chair. Thank you very much, Chair.
Okay, thank you, Mr. Sakaza. Can we get from the department who is in?
Good morning, Honorable Chair. My name is Pedro Seafield, Deputy Director General for Labour Policy and Industrial Relations. I have with me to join me, I have Mr. Tando Wababa, I have Mr. Tembinkosi Mkalipi, and I have from the Compensation Fund, I have Ms. Paula Mkramani, that's also with us in the hearing. The commissioner will join us shortly. He has just other responsibility that he must quickly attend to, but he will join us shortly. Thank you, Honorable Chair.
Thank you very much. Thank you very much, Mr. Seafield. Can we then get the first oral submission, and the request for all those that are then going to make a submission is that their videos must be on, and their when they are making a presentation, because this process is live. Thank you very much. Over to you.
Okay, good morning, Honourable Chairperson and Honourable members. My name is Richard Moody from Relay Emergency Medical Services, EMS for short. This here next to me is Jacqueline van Heerden. She is our financial manager for our organisation. And I think just before we get into the presentation, I just briefly want to say that, so although I am the operations manager, I am also a paramedic in profession. So currently I am busy pursuing a master's degree and with a keen interest in the healthcare system. And I believe that if we are able to close the gap between the pre-hospital sector and the hospitals, we can ultimately improve the patient journey, their experiences, and improve the quality of care we provide to our patients overall. So we just want to start the presentation off with a short video that we will just need to load quickly. Thank you, Honourable Chairperson. I think the video, just what you watched there, were some scenes were simulated and others were real-life incidents and situations that we attend to daily. I think what we have seen through our experience is that injuries and injury on duties occur at any place, at any time, and really can affect any worker, whether it is in the office, whether in the factory, or if they are working on the construction site, as you've seen in the video. So what we do at Relay EMS, we serve 3 health districts within the Eastern Cape province from 4 different bases. And these include in the Nelson Mandela Bay district, the Sarah Baartman district, and also Chris Hani. And we do this with more than 60 permanent emergency care practitioners that work across these bases. And at all of these bases, we attend to injury on duty patients, and many of those cases have been life and death where these workers were injured. And I just also want to briefly share with you what it is like attending these incidents every day and the elaborate system that we need to attend to these patients. So I think first of all, this happens without warning. There's no way of saying when this will happen, where it will happen. And sometimes it's a minor injury with a cut or an injury to the hand or limb, and it's minor and can quickly be resolved. But other times it is a situation of life and death, and these workers can become or have been seriously injured, cases that I've personally attended to in the past. We've had one very recently that I'll share a little with you on later. And I think what we do as EMS we need to respond to these scenes, stabilize the patient, and we then need to provide the initial emergency care that the situation requires. And then after that, we have to find a hospital or an emergency room that will accept these patients. And when we say accept these patients, it means that there is a doctor on duty at that specific emergency room or hospital that is willing to see this patient. They are willing to attend to the patient. And what we find is that that proves extremely challenging. As soon as you mention that this is an injury on duty and this is a worker that has been injured, immediately we struggle to find a hospital willing to accept our patient. And I think for us in EMS, it's challenging. It's at times disheartening when we have attended to this patient and then we want to see this continuation of care happen. We want to see that there's a multidisciplinary involvement, that this patient will see a surgeon if they need a surgeon. They will see a specialist physician if that is needed, because we can only do as much in the pre-hospital setting and in the emergency room. So I think also what we face as a reality is that we have to always be prepared. As I said, these injuries happen anywhere at any time. And in order for us to always be prepared, we require a large amount of equipment. We need highly trained and specialized staff on different shift systems, because it may happen at night, it can happen early in the morning. We don't have the luxury of saying we are off, there will be no injuries during the night. And in order to achieve this in our organization, we require a sustainable financing means. We need to have a steady cash flow in order to achieve this. And I think I also want to share with you just a few pictures of incidents and I have been on most of these scenes that they have happened here in the Eastern Cape, where there were workers that were on duty that were injured. And I'll just talk you a little through some of the pictures. Okay, so this one over here, I think there's two pictures here. This was a vehicle that have overturned on a farm. This was all workers inside the vehicle and on the back. And some of these workers fortunately suffered only minor injuries, others were more serious, and we actually required to evacuate them by medical helicopter. So in this scenario, we worked alongside our Eastern Cape Department of Health, EMS, and I think that those relations are extremely important because we complement each other's services. So in this case, as I say, fortunately, some minor injuries, other more serious, but very inaccessible area. Took us a very long time to actually reach these patients, and we needed an elaborate system to evacuate them to hospital, and again, needed a hospital that will accept our patients. Okay, we'll move on to the next picture. So this one, also two pictures. This was a worker at stables, so horse stables here in the Eastern Cape, just in our Nelson Mandela Bay district here. This worker was injured while working with the horses, and the challenge in this case was we needed to evacuate this person by 4x4 vehicle. So when we arrived, we realized our ambulances would not reach him. It's almost 5 to 6 kilometers to walk. So we activated the rest of our system. We're able to get a 4x4 vehicle to the scene and treated and stabilized the patient, and then evacuated him over this sandy road to where we could meet an ambulance. So again, it's we needed more than just an ambulance that could get to the patient. Okay, and the next picture I'll share with you. This was during COVID, and I think it's maybe just worth mentioning that some of these pictures that I've shown you was pre-COVID, and some were during COVID. So if you see no masks, that was pre-COVID. This was a patient-facing healthcare worker that we transported over 300 kilometers, tested positive for COVID, deteriorated during the self-isolation period, and we eventually needed to place him on respiratory support due to the system and the availability of hospital beds in the other districts. We needed to move this patient over 300 kilometers. And again, very challenging case. This patient survived. He went into ICU at the Nelson, or in our Nelson Mandela Bay District Hospital, but this needed an elaborate system as well. So what happened is he deteriorated along the way and consumed more oxygen than what we initially anticipated. So we needed to activate once again the rest of our system and get more cylinders, oxygen cylinders to us to actually get him to hospital with continuous respiratory support. So again, challenging case, and yeah, again, we relied on an elaborate system that we needed to have in place. Okay, so I think that is, yeah, from the pictures, that's all I have to share with you with pictures. But once again, I have another video that I would like to just show you. And this is one where we got involved with education around the safety of working at heights on construction sites. Although we need to always be ready for when an injury happens, we also believe that education and awareness around health and safety is also part of what we are responsible for. Okay, so I'll share that video with you. We'll just need a few seconds to load it. So again, thank you, Honourable Chairperson. So although it was a simulation and it was not a worker that was really injured, what we did find is we actually found that the workers on the site, they were extremely grateful for what we have shown to them that day. And while I was busy setting up to actually perform this simulation, I had quite a couple of them assist me with setting up the rope systems and all of that we needed. And I'll share a picture with you. And the guys said to me that I think they shared with me that they're always worried for, how quickly this can happen. They have their safety harnesses, but they were always wondering who would take them down if they were hanging there. So it was quite exciting to perform the simulation and get involved with them and also listen to what they had to share and what their concerns that they have when they are working on those sites. And I think also just another picture that I'll share with you is also around the training. And I think this is just to reiterate the amount of training and specialization that is needed in our industry, and that this requires, again, as I said, this requires a sustainable means of financing our organization. So this is a picture of a trench collapse. Unfortunately, in the past, I've attended to some of these incidents, and these are really extremely, extremely dangerous situations and things that can happen, or these collapses can happen often and really require specialized skills. There's not many organizations that can perform such rescues. And again, it's at a time where we need to work together with other rescue organizations and to get or to reach these injured workers and assist them. Okay, so I think that is really around what we do as EMS, what the patients we attend to daily, the situations we are faced with. And I think for today, so I would like to note two concerns that I have around session. One, first concern is that without session, we will not be able to finance our operations as we currently do. So in order to provide EMS, it is more than just vehicles, which I trust that I've shown today. It is staff that we need. It is training that we need. It is systems to communicate. And it is all of this is needed to get the right patient or get the right vehicle to the right patient. We need to get the specialized staff and paramedics to the patient that needs it desperately. So when I say this will affect our operation, I think it will affect more than just injured workers. So not having ambulances in the various districts that we cover. As I've said before, we work with our Eastern Cape Department of Health. What I've learned over the years is that it almost feels like no matter how many ambulances you have on a certain day, it doesn't seem to be enough. You need more at that given point in time. And that is when we need to have close relations between ourselves and the Department of Health EMS. So when our vehicle is in the area and is available, we are able to assist them. When they are there, they are able to assist a call that we have received, for instance. And for that reason, I'm saying that it will not just affect injured workers. It will affect patients, mothers that are in labor, premature born babies. All of those are patients that we assist through financing our organization. And I think all of these patients, not just the injured workers, whether it's road accident victims or these premature babies, they all have a right to timely emergency care. And I think that is what we strive to provide. And my second concern is, as I have alluded, we often find it difficult to get a doctor or a specialist to accept our patient. And as I've said, it's disheartening. We would like to see the continuation of care. We advocate for what is best for our patient at that time. And I've personally encountered where I've transported a patient and the emergency room will accept the patient. We will work with the team in the emergency room, stabilize the patient. And then during that journey, we reach a point where this patient must now be moved to the public sector because we have encountered that there's a doctor or a specialist that needs to continue care and that at that time is not willing to accept the patient because it is an injury on duty. So what I've seen in my 15 years of transporting some of these patients to the public sector, I've never seen a doctor in public sector not willing to assist the patient and not willing to render emergency care or any care for that matter to the patient. But what I have seen is that it is an already burdened system. I've seen that there is more patients than healthcare providers at a time. And what we do, because it's normally us as EMS bringing that patient and adding them to an already constrained system. There's already a long queue of patients waiting for certain interventions or procedures like a CT scan. And we are adding to that queue of patients with the one we are taking to the public sector hospital. And I think, as I said earlier, we recently attended in the Chris Hani district to an injured worker that fell almost 10 meters. And we worked extremely well with the provincial hospital in the district. We were able to get an emergency care practitioner, which is a 4-year degree paramedic, to the patient. They assisted the doctor in the provincial hospital and were able to stabilize the patient to a point where we could transfer him to Nelson Mandela Bay, where there are more facilities where they could perform radiology and CT scans. Of course, as I said, the patient was critically injured. And again, what was disheartening is the efforts that went into caring for this patient. And then when we needed the hospital in the Nelson Mandela Bay district to accept the patient, he ended up in the public sector. And again, as I said, I've seen miracles happen in public sector hospitals. But this patient was just added to the queue to wait for a CT scan to understand what is happening with the traumatic brain injury. And yeah, unfortunately, we learned later that the patient passed away, I think 3 hours after we have handed him over to the hospital. And whether that could have been prevented, I'm not able to say. What I am able to say is that I know that he needed care and he needed it urgently. And I think that that patient could have gotten to CT facilities sooner. And I can only speculate that that would have definitely made a difference in the prognosis. And I think, yeah, as I say, it really is. It's disheartening to deal with these cases. And so today, honourable members, honourable chairperson, I'm asking in the interest of injured workers that you remove clause 43.4 of the COIDA bill. And that will allow us to continue our service that is of world-class standard to the injured workers. If you remove clause 43.4, it will affect more than just the injured workers. Okay, it will keep ambulances and EMS staff on the road. And as I've said, it's not just for injury on duties, it's for the country. It is for those premature babies, the mothers in labor, all of those other patients that we assist. I thank you, Honourable Chairperson.
Thank you very much. Sorry for that. Thank you very much, sir. Are there any questions? I see one hand, Honorable Bagram. Any other hand? Honorable Mkondo. There are 2 hands for now, Honorable Bagram. Then after Honorable Bagram, it's going to be Honorable Mkondo, in that order.
Thank you, Madam Chair. May I go ahead? Madam Chair, hi. Can I go ahead?
Hi, Bagram, over to you.
I'm sorry, I apologize. It took a few minutes to unmute myself. Thank you very much for the opportunity. I appreciate it. And thank you to Richard, I think it's Richard Moody from EMS. Thank you for that presentation. It was interesting. Interesting to see stuff that we didn't know and understand. One thing I did want to ask is just one question. It's clause 43.4 obviously is the nub of what you're talking about today. In essence, if it goes ahead and they do push it through, despite all the complaints, are you saying that you then can't perform your duties at all and you won't be able to help out patients, not only those that are coming through the fund, the compensation fund, but that will affect many others? Is that the bottom line of what you're saying? Thank you for listening to me. I appreciate it. Thank you, Madam Chair. I'm finished, Madam Chair.
Thank you. Over to you, Honorable Mkondo.
Thank you, Chair. Good morning to you, Chair, and honorable members. I welcome, Chair, the presentation from EMS. Chair, my question will be the first one. Did EMS got an opportunity to make a presentation when the Department of Health was busy with the NHI public consultations? Because to me, their presentation is more relevant to that. I understand that they are working with injured workers. That is why they are here. But most of their challenges that they are presenting here, to me, it seems is the Department of Health that can be able to resolve on their behalf many of the things that they have presented here. The last question, Chair, can they give us an average in terms of percentages of public hospitals that are rejecting their injured patients and private doctors or clinics that are rejecting their patients? Thank you.
Thank you, honorable members. Can the relay people respond?
Thank you, Honourable Chairperson, and thank you for the questions. I think the first question is if this clause 43.4 were to go ahead and if they push it through, would we be able to see, will it affect patients other than injured workers? I think the answer is yes. I think part of what we do is we attend to injured workers, but also we attend to any other patient that requires emergency medical services. So that is victims of road accidents. As I've said, it is mothers that are in labor. It is patients that are suffering medical emergencies due to comorbidity diseases like diabetes and patients having a stroke or a cardiac event that causes them to have a heart attack. We attend to all those patients, and part of what we do is injured workers, and through how we do it is we finance our business based on some of the IOD work that we do. And that enables us to be available for any other patient that may require assistance. So I think to answer the question, will it affect patients other than injured workers? I think yes, it definitely will. And then I think moving on to the next question in terms of presenting for national health insurance. I personally have not made a presentation. I think there are challenges on both the private sector EMS as well as the government sector EMS, but I think at this stage what we are trying to bring across is that we work together. There's essentially no other way to put it. We work together for the benefit of the patient. And again, we are here to state how we do this through the IOD work that we do and how we are able to be available to patients other than injured workers. But in terms of NHI, I personally have not presented on NHI. But as I say, we we understand very well that there are challenges on both sides, but at this stage, when we get to the patient, we aim to focus on that, what is best for the patient at that time, whether that is a patient that, as I said, pregnant mother or an injured worker or a road accident victim. To us, doesn't matter. We get on with it and we focus on what is best for the patient at the time. In terms of your question on percentages, I think it would be very difficult for me to give an exact percentage on which hospitals are rejecting patients. I think I've not done a survey in our health districts in which we operate, and I also don't necessarily speak for every other province, although I have worked in other provinces where I have experienced a similar type of scenario where patients are being rejected. I think what we are saying, public sector hospitals, as I've said, I've never come across a doctor that is not willing to accept that patient or willing to assist them. But what I have come across is that there is long waiting times for those patients. And what we advocate for is to get that patient to a hospital or facility, whether that be a surgeon or emergency room, that are able to see them within a certain time frame. When we look at the triage scores that have been developed and validated for our setting in our country, we know that there are certain times we want to attend to a seriously injured patient in under 10 minutes from arriving in the emergency room. And this is well validated evidence that that's what we want to achieve. And I think if we take that injured worker to a public sector hospital, they are able to attend to him. But I think it will be very difficult to reach that under 10 minutes. So it's very difficult for me to answer and say how many hospitals reject these patients. Anecdotally, from my experience, I'm able to say that I encounter that there is often an interruption in the care because there's no progression. There's a discipline down the line. There is a specialist that are not accepting the patient, and that's where the care then ends and need to be moved over to public sector, which I don't think is ethically right to shift that onto the public sector.
Can I just get this clarity from you, or get your response? Yes, a patient may, it's an IOD, go to a private hospital, but what at times determines how then the patient is going to be seen is either a patient on medical aid, and if that patient is on medical aid, what is that medical aid of him or her outlining in terms of how much he is paying and what can be done or what cannot be done. I'm raising this to get this clarity from you of what is your understanding, because my understanding is that you are a private EMS. Okay, I'm not going to talk about what is happening in an MVA situation. I'm just going to focus myself on the IODs because that's where we are. So can you please clarify to us that I'm raising this question because you keep on hammering that they are then not going to be able to be seen after being stabilized. They must then be taken to a public hospital. Now, that's why clarity from myself, is it not because as much as they are IODs, can you clarify for me? They are IODs, but IODs that may not be members of a medical aid, or if they are, their medical aid is not providing this and this and this and this for that patient to be able to be assisted by a private hospital. If you can just clarify for me that, please.
Okay, thank you, Honorable Chairperson. Yes, I think so. When we encounter the patient, we normally start off, and to be honest, the ability to pay determines the facility that we transport the patient to. So when you make mention of a medical aid, a medical aid patient, we will typically transport to a private facility, and that medical aid will then cover the cost of the emergency room, the hospital admission, if that is required, specialist care, and perhaps admission into ICU if that is required. I am no expert on the authorization processes for medical aids, but my understanding is that there is often an authorization process that happens on the administration side while we are attending to the patient in the emergency setting. So that is typically for medical aid. Then, of course, it can happen that when we have an injured worker, that worker may also be on a medical aid. But it started out that the worker was injured on duty, and we treat it as an injury on duty then, and we attempt that the employer complete the required paperwork that we need to take with the patient. And then we transport that patient to a private facility as well. And they often receive the initial emergency stabilization that they require from both us and the emergency room at the hospital. And then there's a process of admitting the patient into hospital. And that's where we encounter the difficulty, that patient is then not, when we say accepted, it means that this patient has been discussed with a specialist and they have accepted that they will take over care of this patient, allow them or admit them into hospital, and then this specific specialist will oversee their care. And at that process, and that is my opinion, and as I said, anecdotally, what I find is that often that is where we hit the roadblock, that the specialist, upon hearing that this is an injured worker and that he will deal with injury on duty and admin and paperwork, that he then says that he will not accept the patient, and that the doctor that is then in the emergency room must then transfer that patient out to the public sector. So that is what I personally see. I have done many of those type of cases. I have transferred that patient. Again, I can share with you stories of burn victims that were on duty at the time, and when there's continuation of care now needed with a surgeon and specialist, we then have to move that patient to public sector. So that means that patient will go into an ICU at public sector and take up the bed of a patient, another patient in public sector.
I still haven't get my clarity, my question straight to you, from you, that a patient at times is not admitted, as much as that patient will still be on medical aid, but because, as you have said, because of authorization, and authorization depends on the type of the medical aid, what is covering that patient and what is not covering that patient. I'm not quite sure. Secondly, is that I don't know whether you people have you ever been to Ben's unit or Ben's ICU of public hospitals to just see? Before you respond, can I get Honorable Bagram? Is it a new hand or is it an old hand?
Please, it is a new hand following up from the question that you asked and the answer we got. Just to follow up on your query.
Can you come up with the follow-up so that he then responds once and for all? Over to you, Honorable Bagram.
Thank you, Madam Chair, and thank you for the question that you asked, because it is important to know what's happening out there and why there seems to be a problem, in the sense that many patients seem to be turned away. The experience that I've been hearing, and it's very similar to what, sorry, I must switch off my phone, I apologize. Apologize for that, Madam Chair. I apologize. The experience I've been seeing is what we're hearing here now is that patients are literally taken into the hospital, obviously at the point of where they're being, if it's life-threatening, they can't turn them away immediately, but as soon as they need to get a specialist, it looks like they get sent to a public hospital away from the private hospital. I don't know if that, and there seems to be a bit of confusion, is that because it's a compensation fund claim as opposed to a claim from the medical aid? There's a big difference between the two. A compensation fund claim creates all sorts of hassles, but the medical aid claim is just getting authorization, and that seems to be quite quick. So maybe I'm following up on the question made by Honorable Dunjwa. Thanks.
Thank you. Okay, so I will attempt to just clarify that more. I think first, Honourable Chairperson, the question on have I been to the burns unit? Yes, I have many times. We have Dora and Ginza here that handle burn patients, and I have transferred many of those patients, and I've personally attended to many life-threatening burns that require a burn unit. So yes, I've gone to those units. I've worked in those units before. And okay, so in an attempt to just clarify it further, I think what I just want to go back to where we receive a call for an injured worker. We then respond to the site or location where this worker has been injured. We stabilize them, and then we transport them by ambulance to a hospital, which would normally be a private hospital. We then need to hand over this patient to the doctor in the emergency center at this hospital. They then proceed with the care that is required, and in an attempt to stabilize the patient. And at that point, if we are dealing with a worker that has no medical aid, they continue to provide care for this worker, this patient in their unit. If they then need to admit the patient into hospital for specialist care or intensive care unit admission, they then contact the specific specialist that will take over care of this patient. That may be a surgeon, it may be an orthopedic surgeon, it may be a specialist physician that the patient needs. Upon hearing that it is an injury on duty patient, and there is no possibility that there's a medical aid with, or that this patient is not a member of a medical aid. If this doctor, if it is their priority to deal with injury on duty patients, so in other words, they understand that this is a claim from the compensation fund. If they are, in a sense, can I put it, happy, if they are willing to deal with the compensation fund, they will then accept this patient, admit him into ICU, and continue to provide care in the private hospital to this patient. That is, if that specialist dealing with the patient is willing to deal with the compensation fund. If it is a medical aid, it is, again, I'm no expert on the medical aids, but what we typically encounter is that if this worker does have a medical aid as well, but he was injured on duty, it is very difficult to just move this across to a medical aid, to now say that the medical aid is responsible for this claim. However, to be honest, that is what the specialists prefer, that they will immediately start dealing with the patient's medical aid to cover the cost of his admission and treatment, rather than dealing with the compensation fund. That is what I have experienced in my career. And if it is a medical aid, they immediately proceed to care for the patient without any concern. But if they hear compensation fund will be liable for it, or they will need to claim from the compensation fund, there's a roadblock. They don't necessarily want to admit that patient.
No. Thank you very much for making that distinction, because it's that distinction that I wanted, because it was not coming across from your presentation. No, thank you very much for your presentation. In the absence of any more questions of clarity, we will then, you are welcome to stay if you want to listen to other presentations. If you want to log out, it's up to you. But thank you very much for your presentation. Can we get the second company, either from Portia, can you call them, or Mr. Sakaza?
Thank you, Chairperson. Good morning, honorable members, colleagues, and guests. The next presenter is Amrita Ranega.
I'm accompanied on this call with representatives of other hospital groups that comprise the membership of HASA. Together, we will endeavor to answer all questions posed at the end of my hopefully informative and intentionally short presentation. Chair, with your permission, I am going to now share my screen and our presentation.
I'm a bit, I see it's RN Ngobo. I don't see your presentation on the screen. Can that be addressed, Mr. Ngobo?
Okay.
What's the challenge here?
Okay, I'm just going to try and share again. Kindly let me know.
There it is. Thank you.
Thank you very much, Chair. In our presentation, we would like to spend a few moments clarifying our constituency, focus on the context and the problems occasioned by the prohibition on the cessation of claims amendment before we submit relevant proposals, discuss suggested enabling milestones for the inclusion of domestic workers into the ambit of the Compensation for Occupational Injuries and Diseases Act 130 of 1993, provide a submission related to the inclusion of compensation for rehabilitation into the ambit of COIDA, and finally, spend a few moments sharing thoughts and proposals regarding definitions of medical associations. Chair, I'd just like to confirm that you are able to see my presentation at this point.
Yes, we are. Can I check with honorable members? Is everybody able to see the presentation?
Yes, Chair.
Yes,
Thank you.
yeah, very
Yes.
happy. Thank you.
Yes, Chair.
Thank you.
Thank you very much. To start the proceeding, it might be useful to outline in slightly more detail who represents HASA. HASA is a hospital association of South Africa comprising of hospital groups, both listed and unlisted. It's inclusive of Life Healthcare, Mediclinic, the National Hospital Network, Netcare, and other independent hospitals and hospital groups, including Wesani Medical Center in Karankua and Joint Medical Hospitals, Joint Medical Holdings. HASA members comprise approximately 80% of acute hospital beds in South Africa, distributed across all 9 provinces. Member operations include acute facilities, day clinics, and specialist medical. Our members also contribute significantly to the South African economy. In 2016-2017 financial year, when HASA last commissioned its review of members' aggregated economic impact, private hospitals contributed 55.5 billion rand to the economy and supported 248,504 jobs throughout the economy. As has been widely reported, private hospitals have been instrumental in contributing to the national pandemic. Chair, the bulk of our presentation today, in terms of time in discussion, as well as the number of slides that we will present, is focused on the prohibition on the cessation of claims by healthcare practitioners amendment. Clause 43 of the Compensation for Occupational Injuries and Diseases Amendment Bill, which I'll be referred to as COIDA Bill going forward. Section 73 of the Principal Act is hereby amended by the addition of the following sections. Any provision of any agreements existing at the commencement of this Act or concluded thereafter in terms of which a service provider cedes or purports to cede or relinquishes or purports to relinquish any rights to a medical claim in terms of this Act shall be void. The effect of this prohibition to third parties, namely claims administrators and service providers, from taking cessation of medical providers' claims. However, it is to be noted that the compensation fund's long history of inefficient administration and payment of claims to, amongst others, medical service providers, essentially gave rise to third-party intermediary services. Their services ensure that medical service providers do not have to have the specialized knowledge required to ensure reimbursement from the compensation fund, and do not have to wait inordinate lengths of time for the compensation fund to reimburse them for services rendered. The effect is that medical service providers have been more able to focus on the clinical management of injury on duty patients. Medical service providers make use of claims administrators and service providers not only in respect of the compensation fund work, but they work with medical aid patients as well. Thus, claims administrators and service providers play a significant role in ensuring debt collection, in ensuring a fundamentally more stable system. This amendment, therefore, has likely wide and far-reaching negative consequences, including the provision of the medical services to COIDA patients at private sector hospitals, and therefore their access to healthcare services as guaranteed in the Constitution of the Republic of South Africa. The stability of facilities through the likely adverse impact on the revenue streams of the private sector hospital, in the absence of claims administrators and service providers, medical service providers will increasingly refuse to treat COIDA patients. This work will then ultimately be pushed over to an already overburdened public sector. This will detrimentally impact the patient's health, recovery, and future well-being, which will negate what is essentially the primary purpose of the COIDA. The removal of claims administrators and service providers from the claims process will constitute a retrogressive measure on the rights of COIDA patients to access healthcare services as guaranteed in the Constitution. Medical service providers should, given the high stress environment within which they operate, be able to focus just simply on clinical work and to use third parties to do paperwork, administrative functions, as well as for debt collections. Consequently, if this amendment is to be implemented, the compensation fund would need to ensure that additional ongoing support structures are put in place to ensure that medical service providers are adequately trained and skilled to deal with the claims process. In the next 3 slides, I wish to highlight 3 further fundamentally problematic areas we've identified, and then we wish to make a proposal. The first problematic is that the full social and economic impact of this amendment has not been investigated at this stage. The socioeconomic impact assessment system, final impact assessment for Compensation for Injuries and Diseases Act, version May 2015, issued by the Department of Planning, Monitoring, and Evaluation, does not set out the full impact of this amendment. There appears to have been no consultation or consideration of the private healthcare sector when conducting these CS activities. This is a significant oversight, as medical service providers will be required to shoulder the burden associated with processing compensation fund claims, should claims administrators and service providers be removed from the claims process. The second problematic is that HASA is unaware of the efforts from the compensation fund and or the Department of Employment and Labor to date to provide cogent substantiation of the rationale for introducing the amendment contemplated in clause 43 of the COIDA bill. For instance, the CS suggests that a benefit of this amendment would be to reduce fraud and corruption by third parties who buy claims from doctors. But there is no basis upon which this purported rationale can be supported, and the very fact that there are extensive laws in place to protect against and or penalize acts of fraud or corruption, the principles of legality. Our submission will simply be twofold. Instead of eliminating what actually works and has been effective for medical services, the Department of Labor should rather focus on what does not work well, namely the compensation fund's claims and administrative capabilities and performance. We now turn to the remainder of our presentation, and thank you for your attention thus far. We're now looking at the inclusion of domestic workers into the ambit of the compensation fund. While HASA members are generally absolutely in favor of this provision, we do wish to make a contribution to enabling milestones for its implementation. As noted, HASA welcomes the proposed amendment. HASA, however, has concerns regarding the transitioning of the requirement into the COIDA framework, as no transitional arrangements are stipulated to provide clarity and to smooth access to services for occupational injuries and diseases under COIDA. This obviously may have adverse effects on the amendment, including its rationality. It will be important to equip employees and employers with knowledge to ensure compliance with the provision. Of course, the requirement places a burden on the Commission to ensure existing backlogs are reduced ahead of the assumption of this positive obligation. It is our contention that the requirement is irrational in the absence of the following milestones being met. The first is that educational campaigns and awareness programs, specifically roles, obligations, responsibilities, as well as consequences for non-compliance and how to comply. Second, guidelines on registration process, in particular, how the registration process works, what is required of employers, how claims are processed, what forms actually need to be complete, and so forth. The third and fourth, it is HASA's suggestion that registration drives are arranged and that a fully functional and properly resourced call center is then supported. We now move to the penultimate issue that HASA wishes to address. In this discussion, we wish to point out areas of uncertainty and a certain lack of detail before we submit our proposal. This is in relation to the inclusion of compensation for rehabilitation into the ambit of the COIDA. The COIDA bill contemplates inclusion of rehabilitation and reintegration into COIDA. There appears to be some clarity that the funds may be paid out of the compensation fund for rehabilitation. An employee's assessment will take into account costs for rehabilitation. The compensation fund, a licensee, or an employer may provide facility, services, or benefits aimed at rehabilitating employees suffering from occupational injuries and diseases. However, what remains unclear from these amendments is when or under what circumstances will the compensation fund or a licensee provide rehabilitation, and to whom and in respect of what will the compensation be paid for rehabilitation, employees or service providers. It's difficult to ascertain the impact of this amendment and thus puts these amendments at risk of contravening the law as previously, the rule of law as previously discussed. It would be irrational to introduce a new category in respect of which claims can be made under COIDA into the ambit of COIDA, which would in effect further exacerbate backlogs and delay payment periods for claims, without simultaneously imposing a positive obligation on the Commissioner to put in place effective measures to reduce existing backlogs. With these points in mind, HASA submits that while it appears that there will be some level of claims processing in relation to rehabilitation, it would be irrational to introduce a new category in respect of which claims can be made under COIDA, i.e. rehabilitation, into the ambit of COIDA, which would in effect further exacerbate backlogs and delay payment periods for claims without simultaneously imposing a positive obligation on the Commissioner to put in place effective measures to reduce existing backlogs.
Zoom meeting at the moment, but are you sure? Unfortunately, I'm in an all-day thing, but I'll give you a call during a gap. Okay.
I'm sorry.
Cheers then. Bye.
I'm sorry. Who is this Honorable Kado?
Yes, sorry.
Please, can everybody mute? Thank you.
Thank you, Chair. We now move on to our final item, and happily, our last two slides before we engage collectively to take your questions. Thank you for your patience thus far. In this short discussion, we point out the term medical associations, which hasn't been defined in the bill. And we actually point out the implications of this and the consequent proposal. It remains unclear to HASA whether medical associations will include hospital groups. This is of obvious and particular import to HASA and its members, who respectfully submit that hospital groups should have the right to be consulted directly with respect to medical aid tariffs, particularly with respect to private sector patients. Accordingly, HASA respectfully submits that it be clarified by way of definition if the term medical associations extends to and includes hospital groups, in addition to doctor groups and allied groups within its ambit. Alternatively, HASA requests that the provisions of Section 76 and 79 of the COIDA be extended to private hospital groups, and in particular, that private hospital groups be conferred rights to be consulted directly for purposes of determining tariff fees for medical aids. Thank you for your time and your patience. My colleagues and representatives from hospital groups will assist in answering your questions. I will now, with your permission, stop sharing my screen and hand over to you, Chair.
Thank you very much. I just want to get clarity. When you say your colleagues and the hospital groups, you're talking about how many people? Because we must be sure that because we don't want a confusing
Sure.
process when questions are to responded to.
Thank you, Chair. We have actually coordinated a group of approximately 5 people that will be able to respond to any questions that are posed according to the relevant topics.
Whose faces we are going to be able to see when they respond to questions?
Okay, the following people are part of the delegation. Dumisani Bumbala, who is the CEO of Hospital Association of South Africa. We've also got other colleagues amongst other hospital groups, Munir Umar, Naz Khan, as well as Gavin Harrison.
Okay. No, thank you very much. Thank you very much. We will then, are you, okay. There's something that I've done. I don't know what's happening. Am I audible, honorable members?
Yeah, absolutely. Thank you, Madam Chair.
Okay. I don't know what has happened in my screen. I don't know what is this now, which made me not to be able to see you, good people. Oh, technology.
Well, I've raised my hand.
I see it's yourself, Honorable Begram, and then Honorable Kadu. I don't know what has happened in my screen. Gosh. Oh, I'm back. Now I see there are, I see now it's Honorable Begram, Honorable Kado, Honorable Mkondo, and Honorable Mdabe. Sure. Honorable Dana, and then Honorable Nonsele. I don't know what is happening in this screen of mine. Can I log out, honorable members, and come back again? I really don't know what is here on my screen. Will you allow me to do that? Just give me a second.
Absolutely no problem. Better
Please.
like that.
I don't know what is happening here.
Chair, why don't you just click on participants and see if the list comes up, and then you'll be able to see a list of
No, I
names.
saw the list, but there's something on my screen that is happening, which I don't know. I saw the list. I called you, so that's why I want to log out. I don't know this thing of gift box. Where is it coming from? My apologies for that. I just want to. I want to go out of this thing. Can I switch it off? I want to leave the meeting and then come back.
You have our blessing, Chair.
My apologies, good people. My apologies. I don't know what was in this screen, which I had to struggle, but I think I've managed to delete whatever was coming up here. Honorable Bagram.
Thank you, Madam Chair. I appreciate it, and I hope you've sorted out that computer. There are some nasties. There are some nasties out there who try and barge into your computer. Bad news. But thank you very much, and thank you very much for the report and presentation from the Hospital Association of South Africa. It's very interesting, and it's interesting that they have also complained about very similar issues that we've been hearing all along, in particular clause 43.4. But I know that HASA has in fact been concentrating on clause 43.4. They also raised the issue about domestics, etc. But I would just wanted to know from the presenter whether there was anything else that you saw that might be problematic in the suggested amendments. For instance, from what I understand is that many claims arise from individuals in the workmen's compensation claiming fund. Many injuries occur to work and from work. Now, if you look at the proposed amendment, you'll see that there is nothing that is covered for those who are traveling to work or from work. And maybe the hospitals have kept records of how many people were injured on the way to work or from work, because from my understanding and from the feedback I've been receiving is that it constitutes an enormous amount of claims. And if that's taken out of the compensation fund, you won't even have those claims under the compensation fund. They'll fall under the motor vehicle accident fund, which we all know is basically destroyed. So maybe you want to make a comment on that. You've also made the comment about the gross inefficiency of the administration of the fund and the inordinate amount of time it takes to pay if there is a claim against the compensation fund. The hospital groups are ideally placed to let us know as a committee, portfolio committee, in terms of oversight as to the examples of that gross inefficiency. We keep hearing that from everyone about the gross inefficiency and about the inordinate amount of time. But these are hollow claims if you don't follow up with some sort of graph or at least examples of what it's all about. So maybe you can help us on that one. You also said that there seems to be some sort of I don't know what the evil of the legislation. In other words, they wanted to amend the Department of Employment and Labour might want to amend the legislation because there's some evil. And you said that might be because they want to try and do away with claims or criminal actions against service providers. You didn't think that was the case. In fact, there's no evil at all. We heard from the biggest service provider that they've never had a claim against them or any criminal action against them. So maybe you should coordinate with the service providers who are telling us that they've never had any claims, so they're not sure what the evil is. And then finally, with domestic workers, you did say there doesn't seem to be a backup system and training and education, et cetera, for domestic workers and for the employers. I think the employers are probably more ignorant than the domestic workers at this point who don't seem to know at all about any of this. We did have a presentation from people representing domestic workers who seem to agree with your submissions, and so it might be interesting if you want to expand a bit on it. So thank you very much for this presentation. It's extremely interesting. It's Michael Bagram. Thank you.
Thank you very much, Honorable Kado.
Thanks, Chair, and thank you to the presenters, especially for a very clear and rational and logical explanation of the flaws of Section 43. I take on board your point that the Department of Employment and Labour should focus on fixing what doesn't work. In other words, the compensation fund's claims and administrative capabilities and its ability to pay claims efficiently and on time, but you don't really provide proposals on how to do that. And my question is, why shouldn't that claims administration... Chair, can you mute yourself? My question is, why shouldn't that claims and administration and payment process be outsourced entirely? And is this something that the Hospital Association has contemplated or explored with the department, or indeed any of the Hospital Association's individual members? Thank you.
Thank you very much. Sorry for that, honorable members. Honorable Mkondo.
Thanks, Chair. We welcome the presentation. It's very, very clear. But again, Chair, the issue of the current COIDA being effective and efficient is coming up. I'm just asking from the presenter as to, don't they think that these claims are directed to the department, not them as service providers? And if there are some loopholes that the department has identified, what can they advise as a way of improving for what is already there? Improving in the sense of reducing fraud and corruption, because that is what the department in some cases has said they have identified in the system. So it's very disturbing, Chair, for the people that are participating in this as beneficiaries, maybe so-called beneficiaries, to say, but this engine is working, so why are you replacing it? Maybe their interests might be questionable. The second one, Chair, is in respect of the rehabilitation that they have said is set to be paid to domestic workers. They are asking a question as to, it is not clear whether it will be paid to the employees themselves or to the service providers. I'm taking the question back to them to say, what will be their suggestion in respect of that? Thanks, Chair.
Honorable Member, Honorable Dabe. Honorable Dabe.
Chairperson, am I audible?
Yes, you are.
Thank you very much, Chair. Let us appreciate the presentation. The first question of clarity from my side is the issue of a contradiction. We are told that the compensation fund is ineffective and inefficient. It takes long to pay. At the same time, it does pay when there are third parties or concessions that has been made. Now, can the presenter clarify to us when does the compensation fund pay and when it doesn't pay? Is it because it has to pay direct to the medical service providers, or it does pay when there are third parties or concessions or sessions that have been made? The second question is in relation to the last paragraph the presenter said, presented to us. The last paragraph talk about not being consulted when the medical aid tariffs are being promulgated. Can she clarify what she meant by that? What sort of, the last one, Chair, it's on the socio-economic study. She says that the socio-economic impact study that was done by the department on this amendment has not been investigated. Has she or has the organization been privy to the socio-economic impact study? If they have, what have they then proposed as under impact study? Thank you, Chair.
Thank you, Honorable Ndabe. Can I propose that your last question of clarity, if you are able to do that, put it in a chat so that it's then being read, because you broke whilst you were making a presentation, if then that is possible. Honorable Dana.
Thank you, Chair. Chair, my questions have largely been covered. I'll just repeat, because Honorable Ndabe's last question was also one of my questions, so I'll just repeat that question. As a major role player in the field, were you consulted or did you take part in the socio-economic impact assessment study that was done in 2015? And then also, Chair, I would just like the presenter just to, again, in short and in layman's terms, explain what the effect would be of Section 43(4) on medical practitioners, hospitals, and most importantly, the workers. And thank you for the very informative presentation. Thank you, Chair.
Thank you very much. Honorable Nonsele.
Thank you, Honorable Chair. Morning, honorable members and the presenters. Thanks for the presentation by the Hospital Association. And I just want to check these two areas. Some of the questions may have been raised, but in a different format. I would want again to visit those questions. The first one is with regard to the rationale that is of introducing clause 43.4, which basically the submission suggests that it's the preoccupation with the fraud and corruption. And the question would be whether, to what extent is the Hospital Association committed to, in fact, to getting rid of fraud and corruption? Because they suggest that the essence of the clause is solely about that. Whether, for instance, is it also not about giving the department opportunities to improve on the areas that they say they are seriously not wrong, which is the question. Claims and fund operates more efficiently and effectively. That's the first question, Chair. The second question is with regard to the area of the inclusion of domestic workers. The submission basically says the inclusion is in fact a bit problematic, for lack of a better word, in the sense that it does not include transitional arrangements. The question is that I have is whether, for instance, Hospital Association has or has it heard about the Concord ruling on this matter and the necessity that this provision should be, in fact, be included. And whether, for instance, taking that into account, whether those areas that they are proposing, are they really necessary? But of concern to me also is the question, for instance, of rather than just the questioning of the inclusion of the domestic workers, but is whether, for instance, do they support just the principle of the inclusion, if they can clarify that. Because the question is further complicated by their question again on the inclusion of the rehabilitation provision, because it does seem that, again, they show a bit of reluctance in terms of understanding and accepting that provision. If, again, they can clarify it as to what do they mean when they say it would exacerbate the claims backlog and all other inefficiencies. Because again, I was a bit lost by their submission. Those are the three areas I would want to request clarity on, Chair. Thank you.
Very much, honorable members. Can I just establish, Honorable Mdabe, is it a new hand or is the old hand?
It's an old hand, Chair. My apologies.
Okay. Honorable Bagram, can you lower your hand? Thank you. There's just one correction I want to make when Ms. Ranika was saying, we're not an ad hoc committee, we are a portfolio committee. Those are two different things. We are a constitutionally formed portfolio committee. Yes, also ad hoc committees do. So we are concentrating, it's not a special work that we are doing. We are doing what is prescribed by law of what and rules of parliament of what a portfolio committee is to. I thought it's important that I clarify that distinction. Thank you very much, Mr. Ranika, Ms. Ranika. Whoever is going to respond, you will indicate, but we'll appreciate that we see their faces, not unless them opening up their videos is going to affect them being audible. Thank you very much.
Thank you very much, Chair. Firstly, I'd like to acknowledge the error. It is certainly the portfolio committee. In terms of delegation of the responses to the questions that have been posed, I'd like to invite my colleague Nas Khan to respond to the claims efficiencies that we raised within our submission and to provide more detail around that. Nas, over to you.
Thank you, Amrita, and good morning, Chair, and good morning, honourable members of Parliament. Thank you for giving us the opportunity this morning to do a presentation. Just to refer to the question that was raised by Honourable Bagram.
Can you increase your volume? Your volume.
Sorry, can you hear me now?
I can.
Can everybody hear me?
Okay.
Yes, we can hear you.
So just to first answer the question that was raised this morning by Honourable Bagram around the number of patients that gets injured to and from work. So in our position, if patients or members of employment are traveling to and from work, if it's not related to the work, then those injuries will not come through as part of the compensation fund. Those injuries are then non-classified as an IOD case. The second issue around inefficiency of the scheme, if the chair will indulge me for a few minutes, I think it's important for the portfolio committee just to have an understanding in terms of the processes that the compensation fund has gone through. It's important to note within the space of 3-4 years, the fund is now changed to 3 different systems. Initially, the fund was on a system called SAP, and then they moved to a new system called Umhleko, and that didn't work as well. And in October 2018, 2019, I stand to be corrected, the fund then moved on to the new system, what they're using at the moment now called CompEasy. In addition to that system, the compensation then fund made a decision at that particular juncture to move away from a centralized processing system to a decentralized processing system. And I think that's been exacerbated in terms of the turnaround time that we as service providers are currently experiencing in terms of inefficiency of claims. It's also important for the portfolio committee to understand the value chain in terms of how do a claim gets to a payment status or an accepted status. And what is happening is there's a dependency within the compensation fund, obviously for the employees to do a registration on their system. And I think part of the challenges that the business sector has felt over the last 18 months is the complexity in terms of the new system of getting a claim registered via the employer. Once that claim is registered, there is a dependency within the fund. They call it an adjudication process. So that claim will not be paid until somebody within the fund adjudicate that claims. And the dependency here is within the fund that the fund relies on clinical staff within the fund to validate the clinical correctness of that claim. It's only after that process that the claim then moves to a payment cycle. From a hospital perspective, we have seen a deterioration up till the end of last year. In the defense of the fund, we must also give credit where credit is due, that we have seen a more stabilization in the last 3-4 months in terms of the payments that we are seeing within the system. The challenge still remains for us as a hospital group is the actual turnaround times in terms of when the claim gets to an accepted status and when the fund actually makes payment on those claims. And we have examples of claims of 180 days, 250 days, even up to 300 days, where those claims have been accepted, but unfortunately have not been paid by the compensation fund. I hope that answers a question around some of the inefficiencies that we have at the moment within the fund. Thank you.
Thank you, Naz. Madam Chair, I'd like to take the opportunity to invite my colleague, Gavin Harrison, to respond to why shouldn't claims and administration be outsourced. Gavin, happy for you to take the lead there.
Thank you, Amrita. Within the context of the proposed amendments, this wasn't necessarily something that was tabled, and we therefore haven't looked at it, but it is something that we'd be very happy to engage on and look at. I think there has been discussion in the past outside within the private industry on this matter, and it's something that we would happily support and be involved in from our side. The answer is as short and simple as that, is yes, it would be something we would engage on.
Thank you very much, Gavin. I'd like to now invite my colleague, Nir Omer, who will then respond to domestic workers in terms of requiring backup systems and training. Munir, over to you.
Thank you, Amrita. Good morning, Honourable Chair and Honourable Members. On the topic of domestic workers, I think it has been alluded to by a few of the members during the discussion and the Q&A. I think from the context that my colleague Naz Khan has just painted the picture on regarding the processes required on a regular claim, it would be no different to that of a domestic worker. I think the fact that they are just included is something that we wholeheartedly support from a group point of view and from providers' perspective. As far as the process that needs to be followed, I think, as you can imagine, just with any employer, where the registration process is required, adjudication process is required. All of these have a set turnaround time. And unfortunately, the experiences are different in provinces or, working through the systems. So as far as the requirement is concerned from our part, I think a fair amount of training needs to be provided to an employer of a domestic, but also for domestic workers to understand their rights and their responsibilities, as well as the process that needs to be followed in order to get the claim lodged with the fund, and more importantly, accepted or adjudicated to be accepted, in which case the fund would be able to pay out. I think the challenge for the medical providers will be instances where a claim has not yet been adjudicated and they stand the risk of not being paid because of discrepancies with either documentation or content that might be provided or not being provided by the employer to the Department of Labor, the Compensation Fund. I hope that perhaps answers some of the questions relating to the domestic workers. I see there is a hand.
Thank you so much for you.
Can you just outline, maybe it's the first time it is the chair that is able to see if there is a hand and then say a person must respond. 2, please can your colleagues indicate if they are in a space where, because we are in a formal meeting here, your background talks volumes. And if then a person, unfortunately, is then going to make a presentation in a place that is not because of the network, that must be indicated. Please, I don't want to assume that we are not being respected. If there is no other response from your team, I see Honorable Bagram want to make a follow-up, but a question that was asked, and Honorable Nonsele's hand is up, a question that was asked was, are you familiar with the process that came about the inclusion of the domestic workers as an occupational group in the COIDA? I see Honorable Bagram, Honorable Nonsele, but can I just wait, get an indication from Ms. Ranika, is there any person who wants to respond on the initial questions before these 2 hands of follow-up? I'll hand over to you.
Thank you so much, Madam Chair. We actually do have a continuation of responses that we've delegated. I would like to invite my colleague, Dumisani Bumbela, who's the CEO of Hospital Association of South Africa, where he will take the opportunity to respond to the question of the Hospital Association of South Africa being consulted on medical tariffs. Dumisani.
Oh, thank you very much, Honorable Ms. Tunjwa, Chairperson of the Portfolio Committee, and everyone else who is in attendance. I would like to get an indication on whether I am audible.
Yes, you are audible.
Oh, thank you. Thank you very much, ma'am. So I think we just need to clarify for the understanding of the committee that the medical aid aspect of the fund, which is the funding side that processes and engages on payments and tariffs and all of that, we would not, as a sector, private hospital sector, we would not be able to deal with the fund as a collective because of competition laws. And therefore, that is why we are keen to see it in writing that there is an intention to engage directly with the hospital groups that are providing services, because that's the way we are permitted to engage on issues such as tariffs and payment mechanisms. And we use that same way of handling these types of matters when it comes to medical aids. Each individual hospital group negotiates and deliberates on issues relating to tariffs directly on its own, and we cannot do that as a collective. And the other question that I thought I could take possibly is the one on the constitutional ruling that has affirmed the inclusion of domestic workers in the COIDA dispensation. I think our presentation does make it quite clear, or at least that's what we thought, that we are fully supportive of this. We are not questioning the ruling, the constitutional ruling. Even without the constitutional ruling, we would have supported it. It has merit, unquestionable merit. The thing, though, that we're trying to point out is that it is important that we don't just put policy or legislation or regulation in place and then not put equally in place the necessary arrangements that are required to ensure that it succeeds and it is implemented. We're not questioning the merits of inclusion of rehabilitation services, and we're not questioning the merits of the domestic worker, the inclusion of domestic workers. We are fully supportive of that. We just want to be helpful in just ensuring that when it is done in a way that is implementable. Thank you. Thank you, Honorable Chair.
Thank you very much, Doc. Can we then, Honorable Bekram and Honorable Nonsele, in that order on your follow-up?
Thank you, Madam Chair. I appreciate it. My follow-up is twofold, actually threefold. The one is, and I beg your apologies on this one, and I can't remember the gentleman's name, but he was saying that the compensation fund only covers people through work injuries. It's not entirely correct. It covers people traveling to work and from work at the moment. That's going to be removed, and that was the nub of my question. The nub of my question was that many injuries are occurring when people go to work, in taxis or private transport or in trains, or coming back from work to home, and they're still covered by the fund. The amendments appear to have removed that, or want to remove that claim. And I was asking the Hospital Association whether they have some statistics on this, so that there might be something worth looking at. The other thing was, a comment was made that we've been through 3 different claim systems where we now have, the reality is we now have the third, well, it's actually the 4th system from what I can remember. So the system itself, the one we've got now, seems to be the most inefficient. We've spent almost R500 million on these systems, and I wanted to know whether they felt that the system had any improvement of any efficiency at all, or is it getting worse and worse? And the final one with the CEO, and thank you for that issue about the domestics. I think everyone's in agreement that the improvement of this whole legislation would be including domestics into the compensation fund, and that's a fantastic improvement. But of course, the devil is in the detail. And you've now made that remark that the devil is in the detail. I'm paraphrasing, obviously, in that we know that people wait for years to get their claims sorted out, and it's almost impossible in some circumstances to get payments. Can you imagine domestic workers and their employers trying to get this ready? So maybe you can comment on that again, because as it currently stands, you have people who are third parties who are experts and still struggling in getting the claims paid. Can you imagine domestics trying to do this? So thank you for this and opportunity again, Madam Chair. Madam Chair, I'm finished.
Thank you, Honorable Bagram. Honorable Nonsale.
Thank you, Honorable Chair, and thanks for the response that I got on the point of clarity, except the area with regard to rehabilitation. I think the group has not responded to it, particularly on the question that they are raising, because the present heavy burden on the would be whether, for instance, is there no value, because I did ask that clarity. If they can just clarify on that point, I'm happy on the clarity that they are giving on the issue of the domestics. Yeah, thank you, Chair.
Thank you, honorable members. Ms. Raniga, back to you.
Thank you so much, Madam Chair. We have delegated the response to these questions. We also have responses to the questions from the previous round that we would also like to respond to. I would like to hand over to my colleague, Gavin Harrison, who would like to address the issue of the travel to and from work clause that was being referred to. Gavin, over to you.
Thank you, Amrita, and Honourable Chair and colleagues. And I just want to, we don't have any information as to what the amount of fraud that is currently taking place in the system is. But purely on a kind of at a higher level is that essentially there's two parties to a fraud. There's someone who's offering something and someone who's receiving something. And what we are concerned about is, I don't think that this will necessarily disappear by excluding service providers and people who are providing the type of administration services that are currently happening. If the inefficiencies remain within the fund going forward, and we have providers that are claiming that this fraud will continue because of.
We can't. Is Mr. Harrison on the road, Ms. Raniga? Because we have lost him. We can't hear on what he's saying. Is he on the road?
Sorry, Madam.
Is he on the road?
Yeah.
Because we keep on breaking.
Sorry, Gavin, we're unable to hear you at this stage. Madam Chair, I think we'll just continue and come back to Gavin. I'd like to invite my colleague Naz Khan, who will respond to the point that he'd raised in the initial response around the inefficiencies getting worse, and have a response in respect of the new system in place. Naz?
Thank you, Amrita, and thank you, Madam Chair, for the opportunity to respond. Just to respond to Honourable Bagram, yes, you are correct. The new system was brought into, you are absolutely correct, it is the fourth system. Just to clarify, it's definitely the fourth system that they've implemented. Just to get clarity on the new system, you know, there has been a slower improvement in terms of the new system that they have implemented. I think the challenge for us at the moment is that the migration from the other systems whether it be the system number 1 or system number 2 or system number 3. Unfortunately, a lot of those claims are not properly migrated onto this CompEasy system. And as a result of that, that's where we're seeing some inefficiency. The current inefficiency within the system is the long delays it's taking for not necessarily the hospital groups, but for the employer groups. And I'm hoping that that during the course of the day that there will be some employers that will make some representation as well. But the challenges that the employer groups are facing with the new system in terms of getting registered onto the system and the time it takes to register that claim onto the new system. So to be fair to the fund, we have seen a better improvement on the new system over the last few months that we've seen comparatively on the old system, if that answers the question. Thank you.
Thank you very much, Naz. Before I hand over back to my colleague, Gavin Harrison, he appeared to be having some connectivity issues. I'd like to also take the opportunity to respond to the removal of traveling to and from work. HASA would like to offer to get back to the committee regarding a view on the removal of traveling to and from work, so that we're able to provide substantive view on this issue. I'd like to now hand it over to Gavin Harrison. He'll be switching his camera off for connectivity improvement.
Thank you, Amrita. Thank you, Honourable Chair and members. I'm not sure how much you lost in my response there, so I think in the interests of completeness, I'll just respond from the beginning, is that we're not aware of what the preponderance of fraud is within the current system. But what we are concerned about is that the fraud won't necessarily go away by removing these third-party service providers. We believe that as long as the inefficiencies and slow payments remain, there's always an opportunity for people who are desperate enough to get their cash in to deal directly with members of the fund in order to get their payments prioritized and paid quicker. So that's essentially, I think by removing the third-party service providers, it's not going to address the fraud. Fraud is a two-way street, essentially, is what we're saying. Thank you.
Can I? Honorable Bagram and Honorable Nonsele, your hands are still up. Is there something new? Okay, thank you. Thank you very much.
Sorry, I didn't lower it.
Okay, no, thank you very much. Can we, Ms. Renika, is it, you have honorable members, any other questions of clarity? I just want to ask Mr. Khan, you keep on saying it's been more than 4 systems, if I'm not mistaken. Can you tell us the first 2 that you are aware of that the compensation fund had?
Thank you, Madam Chair.
Outside Mahluko and ComEase?
Thank you, Madam Chair, for the opportunity once again. Off the cuff, I can't remember the name of the first system, but from the first system, they moved on to SAP completely. And they had the SAP system in place for roughly around about 14 months. And the SAP system was then replaced by the new commissioner then at that time, was then replaced by the system then called Mshluku. And then obviously what has happened subsequently with the appointment of another new commissioner over the time period, the new commissioner then obviously rolled out a brand new system that is called CompEasy, which is more stringent in terms of trying to combat some of the challenges they had with the previous systems, Madam Chair. Thank you.
No, thank you. Thank you very much. Thank you very much. In the absence, I see the hand of Dr. Bomela. I hope I'm correct. Do you want to respond, Chair, Doc, on something?
Yes, Honorable Chair, thank you. Just to put just to put the matter out there for clarity, Chair, that HASA and its members, as well as the entire private hospital sector, is, for the record, against fraud. We would like to assist in combating fraud. And it would appear that in the discussion, that may not have been clear, and we just want to put that for the record, that it is our goal to eliminate fraud and work with any agents, be they government or otherwise, and any authorities to work against fraud. We are anti-fraud, Chair. I just wanted to put that clear.
Thank you very much, Doc. If you may lower your hand. Ms. Ranika, is there anything else, closing remarks?
Thank you very much, Chair. I would just like to also respond. There was a question that was posed to say that, was as a major player within the hospital sector, were we consulted in respect of the CS? And the answer to the question is unfortunately not. We were not part of that study. And then there was also a question, Madam Chair, around providing a layman's explanation of the impact of Section 43, with respect to hospital groups. I think first to point out that if Section 43 is approved in its current form, what this simply means is that, for example, within a hospital system, the doctors that provide, or even the hospitals that provide services, if it is approved in its current form, it would just simply add on to the administrative burden. And instead of focusing on clinical work, it will then, in addition to the time that would need to be spent on clinical work, it would simply be substituted with administrative burden. And I would like to invite my colleague, Nias Khan, to further elaborate on that for me.
Thank you, Amrita, and thank you, Madam Chair. If I may proceed, thank you once again for your indulgence. Just in a layman's term, I mean, it's important for the portfolio committee to understand that from a principal point of view, from a COIDA admission point of view, the hospital groups has always been as follows: that we do not reject any COIDA admissions in the hospitals. It's important to understand that there's a dependency within the hospital groups for a service provider, which is either a clinician or a surgeon, to be the administrator or the admitting doctor for that particular patient. And what we are suggesting within the amendment of the Act, the concern for us would be is from our associated services which we are getting from, or the patient referrals that we are getting from the doctors, that our concern would be is that in the current format, many of our doctors within our hospital groups are making use of third-party administrators to manage the COIDA administration on their behalf. Our concern then going forward in the layman's perspective would be that the impact it would be on future admissions for those particular members that have the right to be admitted into a private facility, that the onus would now move away from those third-party administrators, and it would become an administrative burden then for the medical profession now to administer the administrative work in terms of trying to get that compensation fund or the compensation claim registered onto the system. Thank you.
Thank you. I think that was the last response from your side. And from our side, thank you very much. Mr. Khan, I think as the committee, the compensation fund was the first unit to be in front of us, which then means we are well versed with the processing of what is happening in the compensation fund. For your own information, we have physically, some of us have physically visited. So it's not that we are, when we ask these questions, or we are getting a presentation on a system that we, or entity or a system that we're not aware of. I'm not implying that you should not ask questions, but I just wanted to make that clarity so that you don't leave here thinking that members don't know about. They are accounting to us, and that will be very important. Just to clear that air. Having said that, thank you very much. If you want to remain, it's fine. You are welcome. If you want to log out, you can log out. If you want to come back again, as long as you don't disturb whoever will be on the floor. Thank you very much. Thank you very much for your presentation.
Thank you very much.
The third? Thank you. Can we get the third presenter?
Thank you, Chairperson. The next presenter is Mr. Richard Spoor from Richard Spoor Incorporated. He is accompanied by Mr. George Khan. Thank you, Chairperson.
You said it's Mr. Richard Spoor. Am I correct?
Yes, ma'am.
Thank you. Over to you, Mr. Spoor.
Thank you, Honourable Chair and members of the committee. As indicated, I'm representing law firm Richard Spoor Incorporated, along with my colleague George Khan. Firstly, I should indicate that we are one of a very small number of law firms who actually specialize in the field of compensation for occupational injuries and diseases. Those who act for injured workers and the dependents of injured workers on a routine basis, I think could be numbered on one hand. It is a field that does not attract legal involvement, but we do it as part of because it's a passion of ours. It's an area that we've dealt with for many, many years, and where we feel very strongly about the rights of workers. So we've got about 35 years of experience working in this field, mainly with trade unions and workers. The focus of our submission is on 4 points. The first deals with a new Section 97K, which will enable the Minister to make regulations for the determination of calculation of permanent disability. That's referenced in Section 60 of the bill, where we just want to make a few cautionary remarks. The second is the amendment of Section 30 of the Act, which will permit private insurers, or as we see it, will permit private insurers to come into this field and provide workmen's compensation insurance, and thereby extend the field from the two mutual associations who are licensed to do this work, namely RAND Mutual Association and Federated Employers Mutual, and will now open the field and permit the licensing of other insurance companies to provide this type of insurance to clients, to members. The third aspect we're looking at is the amendment of Section 91F, which deals with legal costs in objections and appeals. That's at Section 58F of the bill, where again, just a few cautionary remarks. And the last item, which wasn't raised in our original submission, which is a very small and crisp point, has to do with the revised definition of dependents to exclude children over the age of 25. And perhaps I can dispose of that point right now by saying the effect of this would be to exclude disabled children who are older than 25. So we come across a number of cases where workers have children who suffer from some disability or impairment that makes them unable to work. and who are dependent on their parents, wholly dependent on their parents, and will remain dependent on their parents for life. And this amendment may well have the effect of excluding those persons from benefits past the age of 25, and that we submit would be unfair and reasonable. So we've just got to be careful with the definition that we don't exclude that class of dependents. If I could just put our submissions into a little bit of, into a broader context. As you're all aware, and you've heard from the submissions over the last several days, COIDA faces a number of challenges. Our perception of the system is that it's neither fair nor equitable, nor is it effective. The problems have been highlighted by numerous presentations. They include inordinate delays in the processing of claims. Something that we are concerned about, because we see it in practice, is widespread undercompensation, where workers routinely, I'd go so far to say in the majority of cases, receive less than what they are entitled to under the Act. We also find many claims being refused, particularly occupational disease claims, where the compensation fund doesn't wish to recognize those injuries of having an occupational nature, and compensation is refused. An issue that we will focus on is what we regard as unfair and discriminatory compensation regime, particularly as it relates to manual workers, less skilled workers, and I'll elaborate on that in a little while. We're aware, because we've heard the service providers talk about the huge difficulties they have in providing care to injured and disabled workers, and particularly when it relates to ongoing medical care. I mean, a typical example is difficulties workers have in accessing chronic medication that they may require for life, because the pharmacies refuse to provide the services, saying the compensation fund doesn't reimburse them adequately. And we see the same with orthopedic interventions that sometimes are required many years after the accident, where workers have enormous difficulty accessing ongoing chronic medical care. A big concern for us is the inordinate delays that flow through the appeals and objection process. The process is hostile towards workers, it's cumbersome, and it's extremely slow. Another criticism that we have, an overall criticism of this system, is the effective exclusion of workers and trade unions from the process. Fundamentally, this is an insurance scheme, and the insured party is the employer, and the insurer is the fund, or RAN Mutual, or Federated Employers Mutual. It is the employer who lodges the claim. It is the employer who submits the evidence in support of the claim. It's not the worker, and in many instances, workers have no insight into what is being prepared and what is being submitted. And to the extent that this compensation is really important for these workers and their lives, and it's in their interest to ensure that a proper, fully motivated claim is submitted, there is a problem that employers deal with it in a haphazard way, submit incomplete claims that do not describe in effect accurate detail the full scope and extent of the injury, that workers are being shortchanged as a result. And this is intrinsic to this insurer model, but I do believe we need to find ways that workers can participate more fully. They're effectively passengers on this bus. They report the accident, the employer submits the claim, employer corresponds with the fund, and at the end of the day, they receive an amount. In that interim process, they have very little input on the course of the matter. There is another overriding problem with the scheme, and this is a concern when we come to kind of the amendments that are being proposed, is that an insurance scheme like this is supposed to motivate and incentivize employers to improve health and safety conditions in the workplace. The premiums that they pay to fund this insurance should be linked to the risk in their workplace. So employers that have an unsafe and healthy workplace or operate in a particularly dangerous environment should be paying more. Workers with a bad record, employers with a bad record should be paying more. And then to reduce their premiums and the cost of compensation, they should improve health and safety in the workplace. That link between the insurance policy and the incentives to improve health and safety in the workplace are very obtuse in the way the system works mainly. So what we're finding is that good employers are subsidizing bad employers, and the cost of injuries and diseases occasioned by bad employers is being borne by the people who do take care. There's not a sufficient correlation between the premiums and the risk that is being paid for. That by way of background, and then turning perhaps to the issues that we want to raise. The first and probably most important, although aspect, is this regulated assessment of permanent disability. So the provision that we're looking at is a very minor change. It simply says that the minister may make regulations regarding the assessment and the way in which permanent disability is determined. Now, permanent disability is already regulated in broad by the Act, and in particular, Schedule 2 to the Act, which stipulates the degree of permanent disability associated with each type of injury. We refer to it as the meat chart. It's a very old chart. It goes back to the 1940s when this workman's compensation regime was first introduced. And what it does is it effectively compensates workers for their impairment, not their disability. The distinction is important, which I'll come to right now, but it contains provisions such as the loss of 2 limbs is equal to 100% total disability. The loss of hand at a wrist equals 50% total disability. The loss of an eye, a single eye, is a 30% permanent disability. Now, one just has to stop and think about that to recognize how unfairly this works. So if, for example, I were a bus driver or a driver or a machine operator at work and I lose the sight of one eye, let's imagine, for argument's sake, just to make it even clearer, I've spent 25 or 30 years operating a machine, I lose one eye. I'm going to be assessed as 30% disabled, even though the loss of the eye means that I will never be able to work in my field again. You cannot drive or operate a machine if you don't have depth perception, and the loss of an eye puts that at an end. So what's he going to get? And this brings us to the undercompensation and the lack of adequate compensation. That employee will receive a lump sum benefit equal to 15 times his salary. Now that's 15 times his salary, that's a year and 3 months salary for an injury that will effectively exclude him from ever working again. I understand if he's a young worker, he could be retrained to do something else, but the kind of example I'm talking about, a bus driver or a machine operator who's worked for many years, 15 months salary is, with respect, not fair compensation for what amounts to a total and permanent disability and inability to perform his work. He and his family face unemployment and a life of poverty and hardship because the compensation they receive is simply inadequate. It gets worse than that. There are some occupations, think about a tradesperson, an electrician, or a mine worker. We come across a lot of cases with mine workers who have suffered very bad leg injuries as a result of rock falls and the like. Now, that worker's leg may well heal, but he's left with a profound limp. He cannot walk without pain. There's a lot of discomfort, and he certainly cannot continue to perform the underground work, the arduous underground work that he did. Again, if this is a mine worker with no education, but 25 years of experience, the fact that he has a profound limp and pain is worth perhaps less than 10%, which is 6 months' salary but he's going to lose his job and he's going to be unemployed forever. So the problem with a meat chart is it doesn't correlate between the actual disability and the injury itself. It works in other ways as well. I mean, I'm a lawyer. Under the Act, I'm also covered by COIDA. If I were to lose an eye, I would be assessed as 30% disabled for my work and I'd receive that benefit. But the truth is I could well continue to work. The same for a leg. If I'm a manager in a department store and I have a profound limp, perhaps I've lost an arm, I can continue to work and the disability is less because I'm a skilled worker. This meat chart affects unskilled workers in particular. An electrician, a common injury we see in workers, blue-collar workers, is a rotator cuff injury. Chronic injury, can't be fixed, can't be cured, leaves him in permanent pain and a permanently weakened arm. That worker cannot work as a tradesperson ever again. He's likely to be assessed at 10 or 15% disabled, which means a lump sum benefit, but it also means the loss of employment. So the framework as it exists, to our mind, discriminates particularly against unskilled workers and has very unfair consequences for them. Now, of course, that is not the focus of the amendment that we're speaking to, which is to allow the minister to make regulations on how permanent disability should be assessed through regulation. That would replace the current system where the commissioner circulates guidelines which are non-binding on the fund and which are not binding on the mutual insurers. And I want to highlight two of those circulars. The first, and although the fund and the mutual associations routinely apply these circulars, their consequences are often unjust, and we at least have the freedom then to challenge the determination, review it in the courts, through the appeals process and in the courts, and get an adjustment. Circular 171 deals with noise-induced hearing loss. It provides that a worker, when he starts employment, has a baseline assessment of his hearing. It's important that that baseline test to determine his degree of noise loss is not always, in fact, routinely, is not a particularly sensitive or accurate test. But worse than that, it doesn't take into account the hearing loss that the worker has incurred before this date. So the idea of the baseline was introduced in 2002. So if a mine worker, when he was required to be assessed for baseline hearing, his hearing in 2002, he was already 25%, had suffered 25% hearing loss. That is going to be his 0 point. So if he suffers another 25% hearing loss, he's only going to be compensated for 25%, not the full 50% that he's lost over his lifetime. And that baseline system is applied very mechanically and has bad consequences. Another example is Circular 172, which deals with post-traumatic stress disorder. Now, in terms of that circular, the maximum benefit, maximum permanent disability which a worker can suffer as a result of post-traumatic stress disorder is 65%. Now, a 65% impairment will entitle him to 65% of 75% of his earnings, which is approximately 50%. So he will get a pension of approximately 50% of his previous salary. But we have many examples where workers injured in catastrophic events, big fires and explosions and underground accidents are, and I know there's cynicism about these psychiatric injuries, but who are truly dysfunctional and unable to work. And we've been battling for years with a number of these cases, trying to persuade through the leading of expert evidence that this person is permanently and totally disabled, and bumping our heads against these circulars and the mechanical application of those circulars. But right now, we still conceptually have the ability to challenge the outcome of the assessment that's made, and the courts are not bound by these circulars, and we achieve some success in reversing decisions in the courts. There are other policies as well that Rand Mutual and the fund have adopted that pertain to the use of hearing aids for workers with noise-induced hearing loss. Now, those policies and practices fall far short from what is desirable. So it is extremely difficult for a worker with noise-induced hearing loss, profound noise-induced hearing loss, to receive binaural hearing aids or to receive the kind of quality hearing aid that would make a difference to his life. The quality and the value of the aids that are provided are inadequate. You understand why this is, because hearing aids are extremely expensive, especially, well, they are very expensive, and high quality digital binaural hearing aids, would, because of the enormous prevalence of noise-induced hearing loss, be extremely costly for the fund and for the mutual assurers. But they don't wish to increase those benefits because they've got a financial incentive not to. The more, if we give workers proper hearing aids that will effectively rehabilitate them and allow them to live a relatively normal life, the assessment is that the cost will simply be too high, and therefore appropriate hearing devices are routinely refused. So our real worry is this: if the minister is going to make regulations, that is binding law, and the scope where those regulations don't accord with what's just and appropriate in the particular circumstances of the worker concerned, we're concerned that that's going to be an insuperable barrier to our arguing why this individual should be treated differently or should receive a higher permanent disability assessment, or receive a better quality hearing aid, or receive other remedial treatments that they might be entitled to. So our view on this particular aspect is that we should be alive to the problem of equating impairment and disability. Impairment, the loss of a finger, if I lose a finger or a mine worker loses a finger, we are equally impaired, but we are not equally disabled. And a system that doesn't actually take into account disability, but only focuses on impairment, is discriminating against unskilled workers. It's profound enough, I believe, to be open to challenge as being unconstitutional, but that's not the issue here. We would like to see, and I understand this comes at costs, guidelines, better guidelines on the determination of disability and compensation. So putting out something very basic and simple, we should say, well, we suggest that the Act should contain something along the following lines. What is the nature, when you're assessing permanent disability and compensation, you must ask yourself the question, what is the nature and extent of the injury? What is the impact of that injury? What is the occupation and training of the injured person? Is he a skilled worker? Is he an unskilled worker? How old is he? Is he a young person who can be retrained and has other opportunities? Or is he 55 years old and never going to get a job again? What is the likelihood of this worker with this disability finding alternative employment? Including post-rehabilitation. I mean, we favor this push that's coming towards rehabilitation, as we've seen in the Road Accident Fund, and it's something to be encouraged. But the fund should be looking at what is the effect going to be on this worker when determining what is appropriate compensation. What is the reasonable likelihood of this worker being retrained and being rehabilitated? And what is the impact of this injury on his re-employment prospects? If those guidelines, a set of guidelines like this was set out in the Act, the fund or the mutual associations or the private insurers who may be coming on board will make a determination and assessment. It will be possible to challenge that determination assessment in a court, and within a reasonable period, we will have developed a body of precedent through the courts that say what is fair and what is appropriate. And it'll be an objective, rational standard that can be developed. The temptation is to be strictly prescriptive, and I know that's a lot easier, but it does have very profound consequences for people. And we don't believe that it's appropriate that people should be only partially compensated under the scheme. And there are arguments to be made about why that should not be the case. Perhaps just the last thing I want to say on the guidelines and so on. When the workers' compensation schemes were introduced, there was a kind of an acceptance that, look, this scheme brings huge benefits. It guarantees compensation, and it's no-fault compensation. So even if your employer doesn't buy insurance and pay the premiums, you're still covered. The other thing is, it doesn't matter if the accident was your fault or not, you're still covered, and that is a good thing. There are important reasons for it. But at the time when the law was developed the way it is now, we had very different understandings of occupational health and safety. So today's approach to health and safety, the modern approach is to recognize that health and safety is something that can be controlled by the management of the company. They can make the health and safety as safe or as unsafe as they choose. There is a cost associated with health and safety, but if you don't do what can be done to minimize the risk of harm, people are going to be injured. We recognize today that looking at fault in these kind of instances is inappropriate. Let's give an example. A crane driver arrives at work and he's drunk and he makes a mess and he injures himself. Well, the fact of the matter is a crane driver should not be allowed to attend at work drunk. And if you should have mechanisms in place to prevent that. It is a preventable illness. And to look at the negligence on the part of the worker is misplaced. Another example, let's say you're a woodworker and you work with saws. Well, statistically, if you've got 1,000 woodworkers working with saws every year, some of them are going to cut off their fingers. It's statistically inevitable. This doesn't mean that in those instances you should be able to say, well, look, this worker was told not to put his finger in the saw blade because he would be hurt. He was warned, he was trained not to do it, yet he did it, therefore he's negligent. That, with respect, is not a good way of looking things. Injuries in dangerous industries are statistically inevitable. It's got nothing to do with the fault. And we don't believe that compensation for occupational diseases and injuries should be a fault-based system. And we shouldn't reduce workers' compensation on the basis that we're doing them a big benefit by taking out the fault requirement. It's not the perk that we imagined it was. Our thinking has changed about the question of fault in an occupational context. The next item that we want to do focus on, and this is quite an important one, is the amendment of Section 30. As I indicated, at the moment, there's the fund and there are the two mutual associations that provide compensation. This amendment will allow I'm not sure if it's the DG or the minister, I think it's the minister, to license other insurers. So it kind of anticipates two scenarios. One, Rand Mutual and FEMA will demutualize. They'll become private companies, because at the moment they're not for-profit entities. And then two, it will open the door to other for-profit entities to come into this business. And let's be clear, this is a business. It's a huge business. I had a quick look at the financials of Rand Mutual before today. They have a premium income of 3 billion Rand per annum from employers who are members of the Rand Mutual and buy their insurance from them. 3 billion Rand is the income. That increased some years ago by almost 1 billion Rand when the compensation fund, by amending the license conditions of Rand Mutual, purported to transfer steel workers who were previously covered by the fund to Rand Mutual. Now, what that meant is that close on R1 billion worth of premiums that were going to the fund were transferred by the amendment of a license condition. And that money, that R1 billion, was diverted to Rand Mutual. Now, how that happened and why the PFMA wasn't applicable and why Treasury approval wasn't obtained for this transfer of R1 billion worth of business from the state, from a state-owned entity to Rand Mutual, which is owned by the employers, still eludes me. Rand Mutual, from its premium income and its other investment income, had an operating surplus in 2019 of approximately R2 billion, operating surplus. Now, it's a not-for-profit organization, but that feeds back to its members through reduced premiums. So there's a financial advantage. So the more profitable in inverted commas Rand Mutual is, which means the higher the premiums and the lower the payouts to workers, the lower the premiums are that their employers can take. So employers have an interest in Rand Mutual to see it operating efficiently, but also in seeing that it pays out as little as possible. Now, I've run into trouble with Rand Mutual before, but the fact of the matter is that employers derive a benefit if Rand Mutual is very conservative with the award of damages and compensation to persons. That's not the same thing with the compensation fund. The compensation fund is an independent fund. It's not a profit-driven fund. It doesn't have members, shareholders, and oversight is provided by the Department of Labor through the DG. The compensation fund we can accept might have financial troubles from time to time, but I understand financially it's quite strong. But it is an independent party. So when I make an appeal against the decision of the compensation, well, first of all, when I'm dealing with a fund, I know that they're not focused on the interests of the employer. They're interested on what does the law say and what compensation should workers receive. And when I appeal them, those appeals are not met with an adversarial stance. They might say, well, these are our policies, these are our rules, this is how we made the decision. But there's not aggressive hostility, which we do with respect encounter with Rand Mutual. One of the other things that happened with the transfer of all this business to Rand Mutual is that the licenses were also amended to allow Rand Mutual to hear objections and appeals against their own decisions. So effectively, we find ourselves in a position where Rand Mutual makes an award. And when we challenge that award through an appeal or an objection, we come before panels that are paid for and appointed by Rand Mutual who now judge these matters. And I regret to say that our experience of those panels is that they are hostile to workers and workers' claims, and it's not a neutral party. Again, I think the amendment to the license conditions to allow them to hear appeals and objections was unlawful, but it's happened and we're dealing with that. I want to say one other thing about Rand Mutual and why, is to say that Rand Mutual is more effective than the compensation fund. So one of the big advantages of Rand Mutual, and I think this is an advantage from the perspective of employers and certainly from workers as well, is that we don't have the kind of delays we have with a fund when we're dealing with Rand Mutual. Rand Mutual is much quicker, it's more efficient, it's more effective. They're easier to deal with, they react to correspondence, it goes better. But there is a big problem about their interests not being aligned with the interests of injured and disabled workers. And this is a problem. Now, what are our concerns if this amendment goes through and Rand Mutual will demutualize? Well, the first thing is we understand that Rand Mutual is contemplating a demutualization. In other words, from being a mutual association to becoming a private company. And on the papers, That will be accompanied by a large BEE deal, because you'll appreciate Rand Mutual is one of those companies which is owned by the employers, who historically white corporations. This demutualization, as we understand it, is going to come with a big BEE component, and is going to be converted into a for-profit business that is involved in short-term insurance, which is largely what the scheme is. So it's going to be converted into a short-term insurer, and then we anticipate in time other short-term insurers will be coming into this business. Now, unless that is very closely regulated, and unless the DG and the Department of Labor are able to oversee the performance of these private companies of their responsibilities on the Act, we are going to run into a problem, because there is a fundamental conflict of interest between the interests of the shareholders, which they will be, versus the employers now, and as opposed to injured workers and the dependents of workers who've died. So we must be alive to the fact that there is a very big risk. There's already a problem with Rand Mutual, and there's already a problem with the transfer of business from the fund to Rand Mutual. I want to note that move was motivated, as we understand it, by capacity restraints at the compensation fund. So basically, the compensation fund wasn't coping with the volume of claims from the metal industry. So they took that industry and passed it over to Rand Mutual, whose systems are more flexible and open to deal with that. So it was kind of, and I'm concerned that we find ourselves in a situation where the compensation fund and its administration is continually being degraded, and its role is being taken over by private insurers. There is no in principle problem with private insurance companies and for-profit insurers, but it requires a very strict regulatory environment, and it certainly would require changes to the objections and appeal processes so that they can run effectively and that they are dealt with by the state and not by panels appointed by Rand Mutual or the private insurers who are going to move into this very large and very lucrative business, potentially lucrative business. The last point that we had raised in our original representations related to legal costs. At the moment, we're free to, the chairperson or the tribunal members who hear our objections and appeals are entitled to make an equitable ruling on legal costs and fees. I want to stress, this is the work that we do is not, it's not profitable work. We lose. That's why we're the only people who do it. It's not a profitable business. It's not a business thing at all. It's extremely difficult to recover your costs, extremely difficult to recover your fair costs. But the way things stand, we can at least challenge a costs award. So if Rand Mutual's tribunal determines that it's not equitable for us to be compensated for the work we did on behalf of the worker and to be remunerated for the medical costs incurred, specialist examinations incurred, we at least have the freedom to challenge it in the High Court. If it is fixed to a magistrate's court tariff, we cannot. I don't wish to overplay this and overemphasize it. I'm just saying that we prefer an equitable jurisdiction rather than a prescribed tariff. The Magic Court tariffs are okay. They translate into about 1,000 Rand an hour. And then they get taxed down and things like that. And there are issues with, recovering medical expenses and travel expenses and that kind of thing. But it's not appalling. We would prefer a more equitable jurisdiction about what is fair and what is reasonable, having regard to the nature of the case, the merits of the claim, the circumstances of the worker, and the outcomes achieved. So again, perhaps because we're lawyers, we like a bit of scope and breadth to deal with it. The last issue that we had touched on was the issue about children and the accidental, I'm sure, exclusion of disabled children, but I've already dealt with that. Perhaps in conclusion, I would like to say that this legislation that we're dealing with, in which we're reforming on a piecemeal basis, is really old and dated. As I said, some of the fundamental principles that underlie it, ideas around what is occupational health and safety management systems and the like, our perceptions have changed fundamentally from the period when this law was originally envisaged. It's a really old law. It's nearly 100 years old now. And there really is a need to consider a more fundamental rethink and reform of the COIDA legislation. The fact that the legislation dealing with occupational diseases in mines and works is in flux at the moment, and there's talk about integrating these two systems. And I believe the Minerals Council has proposed that that new mine workers coming into the industry should be excluded from the Occupational Diseases in Mines and Works Act and move right in under the COIDA Act. And I know there have been ongoing discussions. I believe there's a cabinet decision taken, I think, 1998 or 2008 that kind of said, let's merge these systems. There is a very good reason to say, well, this is a good opportunity for us to take a step back, look at best international practice, considering what respects our legislation is defective and flawed, and revisit it and create an integrated system. In this regard, I just want to recommend a report by the Yale University, a study done a few years ago by the Yale Global Health Justice Partnership, a policy paper by the Yale Law School and Yale School of Public Health, which did a very, very comprehensive high-level review of our occupational injuries and diseases compensation regime and compared it against international best practice. I don't have a reference ready for you, and I'm not technologically placed to do it, but I would strongly recommend to the committee that they obtain a copy of this report and have a look at what are the high-level problems with our compensation regime and what might be done to reform it more substantially. I remain concerned that piecemeal amendments aren't going to achieve the kinds of radical changes that I believe are required to A, treat workers more fairly, B, to ensure that employers are incentivized to provide a safe and healthy work environment, and C, to protect the interests of the state, which otherwise is saddled with a cost and responsibility to look after workers who are injured through no fault of their own, but are injured in the course of their performing of their duties. So I would like to urge in closing then that the committee, not necessarily now or in the immediate future, but that it ask itself the question, should we be looking at more fundamental reforms as opposed to piecemeal changes? Thank you very much, Honourable Chairperson and members.
Thank you very much, Mr. Spoor, if I'm correct. Honourable members, there is the presentation. Any questions of clarity? I see two hands, Honourable Kado, Honourable Bagram. In that order, Honourable Kado.
Thank you, Chair, and thank you too for the stimulating presentation. You focused on sections of the bill that haven't really been extensively addressed in other preceding presentations. My question relates to your concerns on the amendment of Section 30, You say in your physical PowerPoint presentation that Section 30 entities, mutual assurances, licensees, under the amendment would serve a valuable function of ensuring that COIDA is effectively managed and implemented, because the Compensation Commissioner is, quote, notoriously delinquent and ineffective. Those are your own words. But you also present Section 30 as a privatization of constitutional rights and suggest that privatization increases inequality. So my question is, how do you quantify that? I mean, could an argument not be made that if the processing and payment of all the fund's claims over the past 20 years had been outsourced to private sector operators, many more workers would have received compensation and more quickly? And then allied to this, because I don't think you covered it in the course of your presentation, what are your views on the proposed Section 43, which has been the focus of concern of most prior presenters, in particular Section 43.4, which has huge implications on the cession of claims? If you could clarify exactly what your attitude to Section 43 of the amendment bill is, I'd be grateful. Thank you.
Thank you, Honorable Bagram.
Thank you, Mr. Spoor.
No. Sorry, I should have explained this to you, Mr. Spoor. They're all going to ask questions, and then we will give you a time to respond. So you don't respond after each and every question. You will respond after all members have asked questions. Honorable Bagram.
Thank you, Madam Chair. And Mr. Spoor, thank you for this, a very enlightening address, and I really appreciate it. So thank you very much for it. Section 30, I'm just following on from the Honorable COIDA's question. I presume you're very much in favor of it, but I wanted your comment on the fact whether it probably is needed, and you probably needed to have private insurers right throughout because of the inefficiency. Is that what you're trying to say? If the fund was working, you probably wouldn't need private insurers, but maybe you can comment on that. In terms of Section 58F, I think it is, with regard to the legal costs, it's notorious that when one gets involved with government institutions of this nature, the recovery of the legal costs are minuscule. And in fact, rather, you are a rare attorney. I'm also an attorney, but you're a rare bird in the sense that not many attorneys want to get involved in legal fights of this nature because of the fact that they very seldom get refunded their legal costs, even on a wholly successful claim. And maybe you want to comment on that. In terms of dependents, you referred to disabled children, but I'm just thinking a bit beyond that. What about children who are actually still dependent on their parents at 25? We're living in the days in South Africa where there's almost 50% unemployment. So most parents, if they can afford it, desperately want to educate their children with a tertiary education, which often takes them beyond 25. Sadly, that was so in my case. I was 26 already when I was able to go out and earn a living. So maybe you want to comment on that. If my parents couldn't afford to send me to university today, I probably wouldn't have been able to earn a living at all. Just your comments about the delays in processing of claims, and you're saying that happens to be in the majority of cases. We're hearing that from everyone who's giving us feedback. Isn't that the reality? Isn't that, and I go back to your very last point that you made about piecemeal amendments. Maybe they must get the admin right first before they start amending bits and pieces. We know they had to amend for domestic workers. I'm not sure if any of the other amendments were actually needed. I wanted to look at the issue about proper assessments of needs. For instance, if I lost an eye, I don't think it would make much difference to my legal practice at all, or my ability to be an MP. And you're absolutely correct when you say that they need to properly have an assessment of each person and how you can integrate them back into work. We did receive and it might be useful for you to see. We had a presentation from, and I can't remember who the people were, but they were people who do assessments on workability and getting people back into the workplace. And they made the point very strongly that each injury has to be individualized. You have to look at the person, you have to look at the work, etc. And maybe you could expand a bit on that. So thank you very much once again for your wonderful, wonderful input to this committee. I really appreciate it. Thank you, Madam Chair.
Thank you, Honorable Mkondo.
Thanks, Chair. We welcome the presentation from Mr. Spoor, very detailed and informative. Chair, my first question will be, in the presentation, he talked about good employers subsidizing bad employers when he was talking about working environment. My question is, which a section of the bill, according to him, has to be amended and be in a position to address that? And then the second question, he talked about post-traumatic stress disorder. Is he suggesting that in the services that are in the benefits that are given to the affected workers, is he suggesting that there should be funds for counseling? Thanks, Chair.
Thank you, Honorable Mkondo. Honorable Mdabe.
Thank you very much, Honorable Chairperson. Let's welcome and appreciate the presentation. Although I'm not sure whether the presenter did make a written submission during the time when that was open. If he hasn't, with your indulgence, Chair, if we may get that written submission, if he hasn't. My question of clarity is in relation to the last part that he presented, that we need to look at the fundamental reforms of this 100 years old act. Is it his submission, is it in relation to the dysfunctionality of both the compensation fund and the private run mutual, based on the administrative matters that he raised about the run mutual fund? Secondly, does he perceive that the ineffectiveness of the compensation fund has anything to do with the fundamental reforms that has to be undertaken in relation to the act? Thanks, Chair.
From my side, Mr. Spoor, which yes, your presentation is very much empowering. I just want to, just a question. In you having looked into all this, have you at some stage, because you do have a right to do that as a citizen and as a person that is dealing with law, to have make any presentation to government, previous and former, on your observations that are very profound and worse that the law is 100 years old. I don't know whether 100 years old, does it mean it's old, or is it really 100 years old? But secondly, there's an area that I would like, if possible, just repeat it for me before I ask a question about a fault of a worker. Can I don't know whether I had I didn't really pick that up because there's a question that I want to ask to you, but I'm humbly appreciating just that part that talks about the fault of a worker. Then I will then come back with when I'm making a follow-up, I'll come back with the question. There is a hand that is up of Mr. Brian Pivo. If I'm pronouncing that. Is it a person that is with you?
No, Madam Chair.
Come again?
No, Madam Chair.
Can I first establish who is Mr. Brian Pivo?
Good morning, Madam Chair, or afternoon. I'm presenting after Mr. Spoor has completed his. There was a point, however, that he raised that I thought was addressed possibly in the existing Act. So with your permission, I'd like to comment on it and pose it also as a question. If I'm not permitted to, I'm quite happy to stand down.
At an appropriate time, when you are given your time to make a presentation, because it's only members that are allowed to ask questions to presenters. If you want to comment on whatever, when at an appropriate time, you'll then do that. But
Thank
unfortunately, you can't ask a question. It's only members that are allowed to do that. Thank you. Those are the questions, Mr. Spoor. I don't know whether you are alone. If you are alone, they are all your burden.
Thank you, Madam Chair. We were equipped with Mr. Khan to answer detailed questions about circulars and the like. But that doesn't seem necessary right now. If I could just apologize for not explaining this question about fault adequately, ma'am, to begin with you. It's in the past, the thinking was that if a worker was involved in the accident, we had to find out whose fault it was. So was the worker properly trained? Was he negligent? Was he not negligent when he tripped and he fell and he hurt himself? And fault was a big issue of the thing. But what we've done since is the way that the culture of health and safety has developed is we now realize that, look, work is inherently dangerous. Some work is more dangerous than other types of work. So office work is less dangerous than mining or steelworking. And what we know is that when you expose workers to dangerous environments, they are going to suffer accidents. It's inevitable. It's a statistical certainty. So we know that the mining industry is going to generate a certain number of deaths and a certain number of disabling injuries every year. And with the best will in the world, you're not going to change that. So why are we generating all these sick and injured people? Well, we do so because the workplace exposes them to risk, to danger, and sooner or later, they fall victim to that. So the idea is that workers should be compensated for the harm that they suffer as a result of exposure to risks and hazards in the workplace. And the question of the individual worker's fault is, in fact, irrelevant question. You know, no worker. I'll give you an example. Another example is I use the woodworking example in saying that if you've got 1,000 men working on wood saws for a year, one of them is going to cut his fingers off. does it help to say, well, why did you put your fingers in the saw blade? The truth is, somebody's going to do it sooner or later. If that blade isn't properly guarded and if it doesn't have a saw stop, sooner or later somebody's going to get killed. So the question of fault is actually a distraction. It is the conditions in the workplace which are controlled by the employer that determine how safe or unsafe a place is. And we really shouldn't be looking at the question of fault. And most importantly, fault shouldn't be a reason to punish a worker by reducing his fair compensation. So if the mining industry kills and injures people, well, it should compensate them fairly. The fact that notionally a worker might be at fault for an injury or a death is not a reason to reduce his compensation, as this act does. The discount that comes from giving up fault, the quid pro quo that the employers gave, is in fact a false quid pro quo. Employers, just those cases with pollution, polluter pays. An employer is responsible for the environment damage they produce. Well, occupational injuries and diseases are not very different. You run a dangerous business, people will get killed, people will get injured, and we've got to cater for that. You can't hold an employer liable only for the pollution that he negligently causes. You hold him liable for all the pollution that he causes. And the modern thinking around compensation and health and safety is that this is the principle that applies here. And it's that principle that's not reflected in this very old legislation. In South Africa, it dates back to 47. In other parts of the world, it goes back a little bit earlier than that. Then going back to the original question from Mr. Cardo, the Honourable Cardo, about privatization of the compensation scheme. I want to be clear, I'm not opposed to the principal idea of privatization. I pointed out already that Rand Mutual is efficient and effective, and it may well be possible to structure a private insurance scheme system that works. For example, you could simply have a law that says every employer must buy insurance against occupational injuries and diseases claims, and that these are the minimum benefits that they have to pay. That's a very simple law. You can put it in place and it might just work. My concern is the conflict of interest that privatization creates. And I'm saying to deal with that conflict of interest, you need a very good and effective regulatory system. And in particular, a very good and effective appeals and objections process to safeguard the interests of workers. Otherwise, the profits of these companies is going to be the less we pay, the more we earn. The less we pay out, the more profitable we are. And frankly, undercompensating workers and cheating workers out of benefits that they're entitled to is not very difficult, particularly as you've heard, most of them are unrepresented and have very little input into the whole process. So I'm not opposed to privatization, but I'm just saying we need a better appeals and objection system there. And that system must be independent, and to my mind should certainly be provided by the state. On the cession of claims, we're not involved in collecting money for doctors and service providers and pharmacists. So I am alive to the enormous difficulties they have. And I do know that many, many employers give responsibility for the recovery of compensation on behalf of the employees and the recovery of medical costs to third parties, as I believe have testified before you. And cession of claims greatly benefits that. I suppose the employer gets reimbursed at a discount, and then it's the third party's job to recover the money from the fund, and they find a margin in that. But it's not an area where we work or where I have any specialized knowledge. So I would defer on that. And just to endorse what Mr. Carter said about costs, most attorneys won't touch this field. And that is a problem for workers who are unable to find legal representation in claims that are often of enormous import for them and their families. And yeah, there's another aspect that goes along with this no-fault system and this administrative system, which has advantages. But, one of the quid pro quos is that workers can't sue their employers for injuries or deaths. So if a worker gets undercompensated, he's lost his right in terms of Section 35 of the Act to make a civil claim against his employer. That is part of the deal of a statutory no-fault scheme. You can't sue your employer for negligence. But it does have a problem, and it does affect back on health and safety. It means that there's very little precedent in our law about what is reasonable and what is practicable and what can be expected from employers. So because there are never any court cases dealing with these matters and negligence and fault and conduct of the employer, the law is never developed. So our law about what is reasonable and what is required on the part of an employer is extremely poorly developed because of the provisions of Section 35 of COIDA, which effectively mean none of these cases, none of these issues ever become before a judge, and no judge ever pronounces. So that impoverishes the health and safety environment, and means that we don't learn a hell of a lot. I mean, furnace explosions and eruptions. I must have done 20 furnace eruptions. All the time, it's the same accident, the same reasons, water leaks in the furnace, poor maintenance and the like. And it's like every time you come into one of these inquiries, it's like, who would have known? Who would have understood? Because of the lack of legal precedent. And that is a downside of the immunity side. If you look at Zambia, for example, in Zambia, the compensation law is a lot less generous than the South African law, but you're entitled to recover the difference between what you get under the statutory compensation scheme and your common law negligence claim through litigation. That's another model. And I'm not promoting one or the other. I think if we've got a proper statutory system that pays workers fairly, compensates workers fairly, well, the fact that there's no law developed around these issues and there's no civil rights, it's not all that important. I don't have strong views on that. I think the next issue dealt with claims processing delays from Mr. Bagram. I don't know how to fix that problem. It is a problem, but it's not my expertise to know why the systems aren't functioning as well as they could. I take his point about children who are 25 years and older and who are still dependent on their parents. But I also appreciate that the state has to take measures to prevent abuse. The law as it stands now is it carries children get supported until they're 18 years old. And if they're going to go to university for another 3 years or 4 years, as long as it takes them to get a degree. Again, that's a provision that probably discriminates in favor of wealthier and better educated parents. But I'm not sure if you should support children who are capable of working beyond their 25th year, and if the fund should be doing that, or employers can be called upon to carry that cost. And I make I have no position on that. Just in terms of the assessments of claims, there are some very, very sophisticated systems to assess injury. So on the one hand, we've got the meat chart. Then we've got the American Medical Association guidelines on disability. An enormously complex, big volume of documents, which is copyrighted and which costs an absolute fortune to get hold of and to implement. And that's the other extreme, you know, assessing compensation and disability and impairment. You've got these two extremes, meat chart on the one side, a medical association guidelines on the other. I think it is possible to find some kind of compromise, something that is fairer, just, can be efficiently implemented without having to go the whole hog of using, you know, the AMA guidelines. I do endorse the idea of using occupational therapists more to do proper assessments, and that the occupational therapist assessments be taken into account when you decide disability, because that's their job. An occupational therapist will have a look at how you've been impaired and how that's going to impact on your ability to work and do your life. So one of the things that could definitely be done is insisting in the cases of more severe injuries that impact on a worker's ability to earn a livelihood, that an occupational therapist assessment is a critical part of that. The Honourable Mkonto asked about good employers subsidising bad employers, and then asked me to reference the section in the Act that permitted this. Well, the Act is extremely vague on the calculation and determination of premiums. So to my knowledge, we have different premiums for different industries. So if you're an office worker, it's a particular contribution to the fund. And if you're an employer in the mining industry, you pay more because of the higher risks. But it's not selective enough that you can identify that we are in fact identifying good employers versus bad employers. So we're not taking the data that comes in here, assessing it and adjusting premiums and levies on an individual basis to punish bad employers and reward good ones. There's a new problem going to creep into this thing, which is, you know, the proposal from the Minerals Council is that new mine workers are excluded from a DIMWA and come into the COIDA system. Well, that becomes really problematic because occupational lung diseases are diseases that develop over very, very long periods of time. So if I have a mine worker who's worked 15 years underground in a very dusty gold mine, and then he goes to work in a workshop somewhere, and then he develops silicosis or asbestosis or one of these occupational lung diseases, that is going to, the bill and the liability is going to fall on the garage owner, not the employer of the 20 years previously, who actually exposed him to this harm. And you get that with a lot of diseases. You know, cancers, for example, caused by exposure to chemicals, can manifest many years, decades after the actual exposure. The COID system, this act that we have, functions like a short-term insurer. It's designed to compensate for traumatic injuries and dramas. It's not actually set up to deal with diseases and problems that manifest over a long time. Hearing loss is another one. Diseases of the bones caused by literally physical exhaustion, you know, skeletal, musculoskeletal diseases, manifest many, many years later. But our system, in terms of financing the system, the way it's structured right now, it's only going to punish the employer where this disease manifests, and it's not going to have regard to previous employers. If you want to have regard previous employment, then you need a far more complex management system to control who this guy was, this worker is, where he worked, how long he worked there, what he exposed to. And such a system was created under a DIMWA, but it became so big and so complex that that system also fell apart. So bringing diseases into this short-term insurance scheme creates all kinds of problems. And we have to be very careful that we don't end up effectively taxing employers who don't really contribute to the disease burden of workers versus those who do. But how you design that system to achieve that end is very challenging. And all I can say is you must be alert to it. You need to ask yourself, how is the system funded? How are premiums determined? And how does that impact in respect of compensation for diseases and some types of injury, chronic injuries that accrue over a very long period of time. Who's going to pay that cost? And is it fair and just that the employer at the time carries that cost through increased premiums? I'm sorry, there was another question from the Honourable Konto that I didn't get. PTSD counselling. Yeah, Mr. Khan has just helped me there. Dealt with PTSD counselling. I think I indicated earlier, I like the idea of rehabilitation work. We've seen it in the Road Accident Fund, a lot of money and stuff being directed towards rehabilitation, and doubtless it sounds like a good idea here. But you have to be careful. Some people are so damaged that all the rehabilitation in the world, is not going to fix them. And it's particularly the case with psychiatric injuries. Deeply problematic, very difficult, and it's complex, and one has to be careful not to delay compensation unduly while you're so-called busy with rehabilitation. In practice, the law as it stands now is that you assess the person as he is after 2 years after the accident. So 2 years after the accident, that's when you take him, and that's how you assess his permanent disability. If you introduce rehabilitation processes, we run into problems where Rand Mutual will say to us, well, we're not sure if this is final yet. We want another year of therapy. We want another year of medication. We want to see if he's going to recover from his own by himself. And you create a moving target where the final compensation is never determined. And it's a big problem that we deal with. The call for fundamental reforms, the question was asked, I think, by Mr. Ndabe, the Honourable Ndabe, about, is that because of the dysfunctionality of the system? And my answer to that, and problems with the administration, my answer to that is no. The reform is required on a principled basis because of changed notions and understandings about appropriate compensation. Another good argument for fundamental reform is to integrate this act more closely with the Mine Health and Safety Act and the Occupational Health and Safety Act. They don't speak to each other. I'll give you an example. The Mine Health and Safety Act has provisions that workers are deemed to be unfit for further work. And there are provisions in the Act that do that. Now, that doesn't speak to the COIDA Act. So we have examples where mine workers who under the Mine Health and Safety Act are disqualified for for further employment, but they don't qualify for compensation under the COIDA Act or under the MBOD. And, that doesn't make a lot of sense. I'm a 35-year-old worker. I've got 35 years underground experience. I can no longer work in the mine, but yet I don't qualify for compensation. And there are lots of these little gaps between the laws that affect workers unfairly. And they need to be considered if you're talking about, creating a more integrated and substantially reformed regime. The inefficiency problems, these are matters I cannot speak to. I have no expertise in the administration of these systems. A proper workman's compensation, I made a note here, sensitivity to premiums. A proper workman's compensation scheme will make it expensive for employers who don't have good health and safety standards in the workplace, and will reward people with far lower premiums. This should be a real and a tangible cost. And we need to make the system more efficient so it's sensitive to the efforts that employers are taking to minimize costs, minimize risks to workers in the workplace. I would say, however, that when you've got to be very careful because, for example, under the current Act, if you sue the employer for additional compensation under the provisions of Section 56 of the COIDA Act, then that money is recovered by the employer by the fund. They hit them with a big charge and a big levy and a big punishment to top up their premiums. And we do a lot of those kinds of additional compensation claims based on the negligence of the employer. But invariably, those claims are settled privately and without reference to the compensation fund. So employers are choosing to settle these claims, pay compensation to the workers, which we're happy about, but the fund never knows about these settlements. The fund is unaware that a settlement like this has been achieved, and the result is that the employer isn't going to be penalized. In fact, when we engage with employers, I mean, it might sound morally dubious, we know for a fact they don't want to run this matter to trial because if they are found responsible, there's going to be a big uptick in their premiums, and they're going to end up paying an enormous amount of money. And it incentivizes them to settle and do deals with us so that we can compensate workers, and that is our main concern. The Honourable Dunjwa asked about representations. The only feature that we have made representations, and when we have engaged with the Department of Minerals and we have engaged with the Minerals Council, relates to the integration of the compensation system, and more particularly the integration of COIDA and ADIMWA, and we've made inputs on that. You know, these reforms should really be driven by trade unions, and we have trade union clients, a lot of trade union clients, but I think in part to the high turnover in the trade union, amongst trade union officials, we don't really find that this issue of workmen's compensation is taken seriously enough about trade unions. The only trade union, to my knowledge, that has a permanent department that deals with occupational injuries and diseases and compensation is Solidarity. I'm sure they must hope that I've clarified that as best I'm able. Thank you, Madam.
No, thank you very much. Thank you very much, Mr. Spoor. You have clarified that to me, but I then have a question, a follow-up question to that. Because as I was listening to your presentation, you were more focusing on steel and mining. But don't you think that workplaces are to be categorized? I'm raising that. Let me make an example. I go into a factory floor as a worker, knowing very much that it's stipulated that I will have to wear safety gear. Let me make an example, safety shoes. And that area necessitates, because if I don't wear those, I am likely to injure myself. But for whatever reason, I quickly decide to let me go and grab something in the process without wearing. I just want to make me without wearing those safety shoes. I slip, I fall, I break, or I sprain my ankle. Whose fault is it? I'm just making that example. Whose fault is it? I am told it's red, it's in black and white. When I started working here, we were told that don't ever go into that room without wearing your protective clothing in terms of spectacles that you wear that are to protect your eyes. But as worker, I'm raising this because I'm a former worker. I understand at times how as workers we become a bit, should I say, naughty? But obviously a mine worker can't do that. A steel worker can't do these things because they know that to them it's about life and death. So they can't take chances. So that's why I say, don't you think that it's important that we, the challenges in workplaces are to be categorized, and the responsibility, the role and the responsibility of a worker when told that A, B, and C is not being done. I hear the issue of training, because in that we are then being told as workers that we are trained, you shouldn't do this because of A, B, and these are and at times as workers, we tend to ignore that. The last example, I'm a former health worker. We're always been told that you don't push a trolley alone. You don't. You must be two. One the hand at the head of the patient, the other one at the feet of the patient. But at times, maybe because of a number of challenges, but the Department of Health will try and really find a fault. It is, for me, it's my responsibility to explain that we were short-staffed. I'm making an example. We were short-staffed, and I was forced to push this trolley alone. But at times we're not short-staffed. But I'm in a hurry. I want to go off, and I must push this. I can't wait for my partner to come back from tea for us to push this patient to X-ray. Let me push it alone. So that's why I'm just trying to make that. I'm explaining this in pain precisely because your example is in one sector, and a sector that is which workers can take chances there.
Ma'am, if you ask me these questions, I'm unambiguously kind of on the side of the workers to understand this. I think the point that I want to make is this, that the example you use of wearing safety boots, safety equipment. If the employer equips workers appropriately, he trains them appropriately, he disciplines them appropriately, and he introduces appropriate controls, then no worker is ever going to enter that workplace without his boots on, without his safety boots. So, for example, if you don't have proper training and discipline and controls, you know people are going to come to work without safety boots on. It will happen sooner or later. They lost their boots, they forgot their boots, they were in a hurry, there's some other reason. But if you have a man at the door, you check that they've got their safety boots on, then nobody's going to come in. I mean, the best example is one that I alluded to earlier, is an airline pilot. Now imagine a drunk airline pilot gets in an airplane and crashes it. Are you going to blame the pilot, or are you going to blame the employer who allowed a drunk airline pilot to get in charge of that airplane? There it's simple. It is the job of the employer to make damn sure that nobody pilots a plane if there's any prospect that he's under the influence. So with appropriate measures, you can prevent accidents. But you're a health worker, former health worker. Let me give you another example, needle stick injuries, which are very common amongst health workers. Now, if a health worker has been trained, be very careful with needles, dirty needles, handle them in this way, dispose them this way, do the other way. They get trained how to do this, yet workers prick themselves with a needle. It happens again and again. Why does it happen? Because they're negligent and it's his fault, or because it's inevitable? It's not a fault-related thing. Yes, you can minimize needle stick injuries, but you can't eliminate them entirely. So if we were to turn the question around, and every time a worker suffers a needle stick injury, to say, well, whether I compensate you or not depends on whether it's your fault, Did you make a mistake pricking yourself? Yes, of course I did. I'm a worker. I do the stuff all the time. I do hundreds of needles. Today I made a mistake. I pricked myself. Does that mean that the employer has no responsibility to compensate that person if he develops AIDS or COVID or something from that injury? So there's a difference between, I have a rough surface in the workplace and a worker trips and falls. Well, you can say, well, why didn't you keep a proper lookout? Why weren't you careful? Why didn't you do that? But the truth of the matter is people are going to trip and fall. And you can say individually it's negligently, but as a statistical thing, it's not negligent. And you also made the point, ma'am, I think it's very good. We see a lot of accidents where workers haven't followed the correct protocols. But what we see has happened is this. The employer ticks a lot of boxes. He has protocols and procedures in place. He has them sign off their training certificates and the like. The worker makes a mess. And they say, well, you were trained not to do this, yet you did it. But what's happening here? You made the point about short-staffed. Secondly, there's production pressure. Thirdly, there are bonuses. You've got a tiny basic salary, but your production is everything. So on the one hand, employers are setting rules. On the other hand, they are permitting and encouraging workers to break the rules. But when something bad happens, they blame the worker. But employers put a lot of pressure on people to deviate from prescribed laws and standards in pursuit of profit through higher production and bonuses and the like. So it's a very, very difficult question. And then as a policy choice, you say to yourself, look, the employer is incentivized to minimize injuries because it's going to cost him a lot of money. And he must take those reasonable measures. But we shouldn't be penalizing the workers who are injured for no other reason than because they're at work. They are engaged in the business of making a profit for the employer. They're exposed to risk when they do that. And as and when that risk materializes and they suffer harm, well, that should be a cost of doing business. If you create a risk, you must be responsible for the harm that ensues from that risk. I hope that is helpful, ma'am.
Yeah, it is. It's quite an interesting, my very last, I usually don't do this, but it's quite that you have identified that trade unions are weak with the exceptions of solidarity. What could be, in your own observations, what could have been the causal factor of this? You did say it's turnover, among others, but what could be the other causal factor of the weakness in the trade union movement?
I think the biggest factor is how I alluded this during the presentation about how this is an insurance scheme and the insured is the employer, not the worker, and the insurer is the fund or Rand Mutual. There's no role for trade unions in this process. So what typically happens, a worker gets injured, he gets dismissed, and he gets compensated. Where is the role of the trade union in this process? They don't get to see or assist him in the lodging of the claim. In fact, the worker doesn't even lodge the claim. The employer does it. The employer obtains the medical records, fills in the forms, submits the claim. There is no role for workers and trade unions in this process. The job Solidarity does is actually more in the form of legal work. It's kind of legal work that they are doing on behalf of their members, pursuing claims and the like. But shop stewards and ordinary people on the floor are simply not involved in the process. George points out to me that Solidarity also do a lot of objections and appeals. This is outside the competence of the trade unions. You need specialist people to do it. So unless workers, the trade union's role in this process is very limited. Once the worker is dismissed and left, he stops being a member of the union. And frankly, he's lost to the union, and his grievances years down the line about not getting medicines or not getting an additional operation he needs, it just doesn't come to the attention of the union. So I think it's those two factors. Turnover, because this is a complex field and it takes years of training and experience, And if you have turnover in staff, you lose those people. But the second factor is the lack of involvement of workers in the processing of their own claims. It's virtually impossible for a worker to access the records and determine where his claim is in the process and to intervene in any way. Everything has to be mediated through the insured, which is the employer. And this is a big problem with this insurance model that we have, that it's not the worker who's the insurer, it's the claimant, it's the employer who's the claimant on behalf of the worker. And often, his interests are not to maximize the benefits that the worker would get. So employers do not, in general, submit claims in a manner that accords with the very best interest of the workers.
Thank you very much, Mr. Spoor. Thank you very much. All presentations are empowering submissions and oral submissions. They are all empowering. But yeah, this one has opened, I'm sure even other members have opened our eyes, and I'm sure even the department, because you have raised some very valuable valuable input in empowering us, as we will then be engaged, because we are still going to deliberate as workers. I'm sorry, as members. Honorable members, we are close to 10 minutes before lunch, before 1 o'clock. I'm not quite sure. I want to check with the next presenter, which is Mr. Brian Pivo. Just want to get his indulgence. If we break, will it be fine for him that we break for lunch, even if it's 30 minutes, and come back? Before I check with honorable members, Mr. Pivo?
Madam Chair, that's perfectly fine.
It's perfectly fine. All right, honorable members, are you fine, members, that we can break for 30 minutes and come back?
Yes, we're fine, Chair.
Yes, Chair.
Welcome, Honorable Nkabane, with your smile. Okay, 30 minutes is then. We'll be back 20 past 1. Am I correct? Yes. We're going to be back 20 past 1. Just grab an apple. We'll be back just now. Thank you very much, honorable members. If you log out, you will use the same link. You can log out, come back using the same Members and our guests, I can see every members have logged in, and the next presenter has also logged in. I will hand over to you, Mr. Brian Pivo. Over to you, sir.
Good afternoon, Madam Chair, honourable members, ladies and gents. I'm going to be sharing my screen with you with your permission and taking you through a slide presentation which helps me pace and helps me not forget. Do I have your permission to do so?
Yes, sir. Yes, sir.
Thank you. I'm just going to switch over to the first slide and go over to slide presentation mode. And then switch over to sharing screen. Okay, do we have the screen showing Parliamentary Portfolio Committee Employment and Labour comments on the COIDA Amendment Bill 2018?
Yes.
Thank you very much. Excuse me for a second, I'm a bit slow. We have 4 parts to our presentation, introductions and overview. 2 is general comments on the proposed amendments. And then the third item, items of concern by degree of seriousness. And then lastly, conclusions and questions, under which I have only 1 slide. We are a small company of 30 people. The work that we do is to assist employers with their workers' compensation administration and compliance. Our client base includes about 1,000 employers and their workforce of about 500,000 employees. We are paid retainers by our clients essentially to outsource the administrative responsibilities that they have. And I stress the administrative responsibilities that they have and for which they would otherwise have to employ staff and pay salaries to take care of the administrative component of their compliance and workers' compensation administration. We also assist members of legal insurance such as Scorpion Legal Protection, whose members require, once again, administrative services regarding their workers' compensation claims. In our current guise, we've been around since 2002, although turning to our next slide, you'll see from our photographs that we are not very young, and the first 3 of us in the list here, myself, Brian, Celia, and Corey, have been around in the workers' compensation environment since the 1980s and the 1970s. Johan and Ravishni are newer blood on our team. I'd like to turn to the general comments that we have with regard to the proposed amendments. I think that in general, we see the Act or the bill is making positive changes to the Act. The fact that we are now enfolding domestic workers from private households, which is a proposal that predates the recent Constitutional Court judgment, was something envisaged by the current administration and is an indication of I think, the open-mindedness that we've seen with the current administration in the fund, and which we welcome. We see also attempts at modernizing the Principal Act. There are several provisions in the Act that bring it in line with prevailing law, which is our last point on this. But in general, we see moves towards modernizing. We accept the fact that the administration has taken and the legislation has taken a certain position with regard to the structure of workers' compensation in South Africa. We have elected not to go the route of common law claims. That's a decision taken in Jooste versus Score supermarkets at the dawn of our constitution. and the decision is being followed through. We're sticking with a fairly structured and I think a well-established piece of legislation that requires an element of sprucing up, but sticks to the original principles. We see it being positive in that it restores the role of the Compensation Commissioner as the accounting and responsible officer for the fund, and no longer refers to the Director General in many instances. Anyone who's had dealings with the Compensation Fund will be familiar with the fact that correspondence addressed to the Director General is in any event referred to the Compensation Commissioner. So it's refreshing to see that coming through in the legislation to reflect the status quo. We also welcome the emphasis that's now being placed on rehabilitation and reintegration. We seem to be at odds with the previous presentation, but I see that, or we see that the Act simplifies and improves upon the no-fault principle with certain aspects such as cover which was available only to seriously injured employees in the event of serious and willful misconduct now falls away. And even in the event of serious and willful misconduct, the employee still enjoys cover irrespective of the degree of injury or disablement that he or she suffers. There are, however, important negatives in the changes to the legislation. The first one might appear to be a trivial one, but we think we see it as a particularly important one, especially with regard to prescription as it has applied in the past. And that is, we have essentially 3 tiers of employer in the legislation. The one is the regular employer, such as ourselves and our clients. The second is the employer who's exempted from paying assessments, which is an employer such as the state, as well as an employer such as those who are in the mining or the construction or the steel industry who are insured by the private insurers, and therefore exempt from paying assessments to the compensation fund. They, however, do pay assessments if they are privately insured with the RMA and with FEMA or FEM, but they are not employers individually liable. An employer individually liable is the state, essentially, the various organs of state who carry all of the costs related to the injuries and can't insure for them or don't insure for them at all. So there are 3 tiers, and the distinction between them is often grayed out in the wording of the legislation. In some cases, it's not clear whether it's intentional or whether it's just an oversight. Some of these issues were dealt with in a recent Supreme Court of Appeals case, where the court found that some of the wording was vague and it would have assisted them in their decisions had they been more clearly spelt out. In this presentation, we're going to be discussing the items of deep concern. There aren't many of them. There are 8 of them altogether that we've enumerated. They're in areas of penalties, institutional capacity, and where regulation we think should be called for. So we are not addressing the remaining 29 points that we raised in our written representation, which are covered in the point above, with the various tiers of employer, and then lastly, typographical or grammatical areas, which we found quite a few of in the draft bill. We're now going to turn to the various items of concern. We've listed them here. I'm not going to discuss them any further, but it was important for me, at least, to be able to list them so that I knew how many we're working with. On to the first one, and we have tried to list them by degree of seriousness. So these are issues that we've raised with the most important or the most serious issue that the draft amendments bring to the fore. Section 19, which amends Section 39 of the Principal Act, and 39 of the Principal Act refers to the reporting of accidents, which has been a bane for the compensation fund since as far back as I can remember. And from an administrative point of view, is an issue for both the compensation fund, injured employees, the employer, and providers of medical services. So the proposed amendment is an employer excluding an employer referred to in section 84, and those are exempted employers. And employers, I should be more specific there, those are employers who are individually liable, who are self-insured essentially. An employer who fails to comply with subsection 1 shall be guilty of an offence, falls away, and shall be liable to a penalty of 10% of the declared annual earnings of that particular year. Our issue with this is that subsection 1 requires an employer to report an accident within 7 days. Our first issue is with the word declared, which you've highlighted in blue text. An employer declares earnings in the annual return of earnings for all employees. Now, earnings as defined in the Act are earnings for a particular employee. However, the way that earnings is used, or the term earnings is used in other parts of the Act, refer to all earnings paid to all employees by an employer over a period, in this case, over a period of a year. So the impression that this amendment appears to bring is that the employer will be liable to a penalty of 10% of the declared annual earnings of the particular year for all employees, not for that particular employee. And the issue there is around the word declared, because an employer doesn't typically declare earnings for an employee when they report an accident. When they report an accident, an employer would report an accident, would in the report state what the earnings of the individual employee are, and those would form the basis of any benefits paid to that particular employee. 10% of declared earnings for all employees for the employer would typically be 7 times the annual assessment that an employer pays. And if an employer were to be late 10 times with reporting an accident, if the accident is reported after the seventh day, then the employer would be looking at paying his entire wage bill by way of a penalty. And if we read, going on to the next page, if we read on the next page that the employer shall be liable, there's no discretion on the part of the commissioner to raise the penalty. The employer would be looking at paying his entire wage bill by way of penalties should he experience 10 accidents that he doesn't report within the prescribed time. So we believe the choice of the word declared is unfortunate, and a different word should be used, perhaps the word reported, so that it isn't misconstrued or incorrectly applied in 10 years from now, when the current legislatures are no longer in the picture. Issue number 2 is the prescribed manner. Since 2014, which is the dawn of online accident reporting, prior to 2014, accidents were reported on a handwritten or typed employee's report of accident, which was delivered by paper to the compensation fund. It is actually not possible to report accident in the prescribed manner. The compensation fund typically does not process paper reports of employees' reports of accidents or occupational diseases. They have to be done online. However, the crux, which is the last point on the slide, is that the current CompEasy system prevents or delays reporting until or unless all aspects, and sometimes even more of the accidents or disease, are known. And if you look at the typical COVID-19 questionnaire that needs to be filled out in the event of a COVID-19 case, some of that information can only be gleaned quite a long time after the disease has been diagnosed, or it's been found by the employer that the employee is suffering from the disease, making it impossible to report within 7 days. As a consequence, we are looking at a situation where the employer is unable or prevented by the executive from actually reporting in the prescribed time, and becoming therefore immediately and automatically liable for a fine. At best, 10% of the employee's earnings, and at worst, 10% of all of the earnings for all employees. An issue that was touched on our previous presentation is issue number 3, which is employer-based reporting versus employee claiming. Now, South African law requires that employers and doctors report accidents. An employer and a doctor do not claim on behalf of the employee, they simply report the accident, and it's left to the commissioner, the Director General in the current law, to examine the contents of those documents and decide whether liability belongs to the compensation fund. That isn't typical for the way claims are dealt with throughout the world. In many other jurisdictions, it's required that the injured employee themselves submit the claims, and it is in fact a claim, so it's a demand for payment from the institution or from the insurer. One could argue that employer-based accident reporting is a remnant of a paternal past, as we stated there. If it is something that's forced upon us, and if it's something that we're not going to be changing and continuing to live with, we need to be more flexible, and we need to be more practical about the way in which employers are permitted to report. And if the report is done in the prescribed way, which is a paper-based employee's report of accident or a paper-based notice of occupational disease, then the 7-day deadline isn't an impossible one to meet, but it does become an impossible one to meet if the systems which we are meant to use make it impossible. So in summary, the institutional hurdles placed before employers render compliance impossible, and the resultant fines that shall be imposed will potentially put employers out of business with the wording as it currently stands. We continue with section 39, which is the reporting of accidents. This is our second item of concern, and it's raised under section 19, and it is if an employer excluding an employer fails to report an accident in prescribed manner, the commissioner may impose a penalty equal to the full amount of compensation payable plus interest from the date of accident. Now, this is a bit strange because it places us in a position where we have a further penalty. We note under issue 1 that the revised section 39.6 replaces an offence with a penalty that shall be imposed. Now, we are sitting with a proposal, with proposals in the draft amendments which should be welcomed, and that is replacing an offence with penalties. So we're decriminalising offences or transgressions of the law. And that is welcomed, and we believe it's the correct approach to follow. In this particular instance, however, a further penalty, we can now see that an employee who reports an accident outside the 7 days could be faced with a fine referred to in the previous slides, as well as a penalty including the costs of a claim. The value of compensation, as we state here, includes the capitalized value of pensions. So a young employee who is killed and who leaves young dependents and a young widow, as well as expensive medical expenses prior to his or her death, could be raising the cost of a claim in the millions of rands, and this becomes a penalty which is added to the prior penalty. Therefore, 2 penalties for one's transgression, and we question that. The second issue with regard to this amendment is a prescribed manner, which we've already discussed. And the third issue is something that we've discussed as well, which is employer-based reporting versus employee claiming. These are issues as well for the second issue of concern to us. The third item of concern to us, and the third in priority, is the amendment to section 83. And this is deeply troubling for us as well. The amendment would now read, if the earnings actually paid by an employer in respect of a particular period from the current estimated earnings shown in respect of that period in the return concerned, the Commissioner shall adjust his assessment accordingly. The original wording in the Principal Act is reproduced below. If the earnings actually paid by an employer in respect of a particular period different from the earnings shown in respect of that period in the return concerned, the Director General shall adjust his assessment accordingly. The issue for us here is that the section must apply to all earnings incorrectly shown, not only to earnings in the current that are currently estimated. Firstly, we don't know what it means to be currently estimated. Secondly, it seems to impose some form of limitation. And going back to the spirit, or what we believe is the spirit of 83A, is the assessments that the compensation fund raises are based on the earnings actually paid by the employer. The risk that the compensation fund is exposed to is directly linked to the earnings paid by the employer. The assessments that are raised and the assessments that are paid are on a formula which translates the earnings paid by the employer via a risk rating into the assessment. And that's well established. It's been in place since the dawn of the Workmen's Compensation Act in the 1930s. If the employer reports earnings that are incorrect, whether the incorrect earnings are reported intentionally or otherwise, when the assessment is raised, it is raised on earnings that do not reflect the risk which the compensation fund is exposed to for that particular employer. And the purpose of this section is to bring the risk in line with the assessment in line with the actual risk. Now, if we limit the period for which the actual earnings, or sorry, the assessment must be brought in line with the actual earnings, then we are potentially compromising or placing a risk on both the employer and on the compensation fund. The risk to the employer, which we'll see from the second page, is that it's all too easy with the online systems which are currently in place for an employer to make an error in reporting earnings. And the second bullet point is actually something that we've experienced in practice, which is skipping a decimal point. So should an employer forget to actually type the decimal point when reporting their earnings, they could end up with an assessment that is 100 times overstated. So instead of paying 1,000 Rand assessment, the employer could be spending 100,000 Rand on their assessment, which is obviously way out of line with the risk that they pose to the compensation fund. We are concerned that any adjustment to the commissioner's ability to correct the assessment to bring it in line with the actual earnings is prejudicial to both parties. We believe, therefore, that no limitation should be imposed to the commissioner's right to correct an assessment and to bring it in line with the actual earnings. And specifically, our concern must be that the time at which the error is discovered or made might not be in respect of the earnings currently estimated. And as we indicated on the previous slide, whatever that might be, we're certainly not certain of what currently estimated means. Turning to our fourth item of concern is Section 20, which amends Section 40 of the Principal Act. An employee who fails to comply with the provisions of the section shall be liable to a penalty equal to the full amount of compensation payable plus interest. We're concerned that the penalties are all stated as the amount of the penalty and not as maxima. This might in law be trivial. I'm not sure. I'm not a lawyer, but we would expect it to see wording that reflects penalties should not exceed a full value of the compensation payable plus interest. And this principle applies not only to this particular section, but to others as well. We raise as our fifth item of concern Section 16, which amends Section 30. We have been introduced to it, if not by previous speakers, by previous presenters, but certainly by Mr. Spoor, the fact that this appears to be some form of privatization of workers' compensation. The minister may, for such period and subject to such conditions as he or she may determine, issue a license to carry on the business of insurance of employers against the liabilities to employees in terms of this act to a licensee, provided that the minister may from time to time order that the licensee deposit securities considered by the Director General to be sufficient to cover the liabilities of the licensee in terms of this act. We assume also that the Director General was an intentional use of the word Director General and an allocation to the Director General, not to the Commissioner. Excuse me. Our concerns, I think, reflect those made by the previous presentation, and that is bases and criteria for awarding licenses, including the existing licensees, we believe should be included in a regulatory framework which is not called for in the proposed amendment, nor is it assumed that it's going to be provided. We're concerned also that in the event of privatization, and I insert that in inverted commas, is that the arbitration of disputes, which should be against awards and accepting of claims, determining of rates and those kinds of things, should be, at least that arbitration phase or stage, should be in the hands of an objective party, and typically we would see that being in the hands of the compensation fund or the minister. We also believe that the regulatory framework should not lose sight of the fact that the objective of the amendment is to avoid preferential procurement. In other words, contravention of Section 217 of the Constitution. And when Mr. Mafata made his proposals for amendments to the legislation, he made it clear that the adjustments to the wording of Section 30 were in order to bring it in line with the Constitution, and specifically with Section 217. We would want to see that the regulatory framework ensures that that particular objective is not lost sight of, especially in light of the last point on the last bullet point on the slide, which is the risk of capture. We've put together this graph, and we recognize that not everybody would be terribly fascinated by the numbers, but this shows in the solid black line the revenue collected by the compensation fund in the period 2014 to 2020 in thousands of rands. So we're talking about, I beg your pardon, those are actually millions. So that's actually 12 billion rands worth of revenue in the most recently reported annual report. The bars underneath reflect the claims costs that have been paid out by the compensation fund. And the teal, the greenish color on the top reflects the expenditure on medical expenses. Can we see that a significant portion, close to 2/3 of the expenditure by the fund on claims costs, go to medical expenses. However, the message of this graph is in these arrows, which indicate the surpluses or operational surpluses, or the differences between revenues collected and claims costs incurred. And those are significant numbers. And privatizing the fund, or even partly privatizing the fund, or continuing with the extent of privatization such as we currently have in the hands of the two mutual associations, which are likely to be demutualized on the enactment or the passing of the bill, exposes the industry as a whole. We're talking about all employers in the country funding significant surpluses that should not be finding their ways into private pockets, and by the same token should also not be kept in state coffers. They should be redistributed back to the employers, in our view. This slide highlights the decision taken by the minister in October 2014 to transfer Class 13, which is essentially steel work, to the RMA. And I highlight the third last paragraph, that all current Class 13 employers, I beg your pardon, the second last bullet, that after 28 February, all Class 13 employers will be transferred to the RMA. This is unusual by virtue of the fact that the RMA and FEM competed with the compensation fund prior to 2014 for employer business in the mine and the construction industries respectively. However, from 2014, the entire Class 13 or steel manufacturing sector of our economy was moved to the RMA. And an examination of the RMA's annual reports will show that they certainly enjoy significant benefits from this transfer. Moving on to the next point, and I think this is our third last item of concern, is Section 73, the amendment of Section 73, or the addition of the new Section 73, which I think you've been exposed to a great deal of discussion about over the last few days. The first issue with it, we believe, is that it may be unlawful. Much has been written on in other submissions based on the unlawfulness of the proposed new subsection. We have nothing to add with regard to the unlawfulness or perceived unlawfulness of the amendment. However, we do have a comment to make with regard to the impracticality for not only providers of medical services, but for employers, employees, and the compensation fund. And we would just like to dwell on these 3 points. Firstly, employees do not easily obtain medical services of their choice due to the administrative burden on providers who treat COIDA patients. It's a fairly difficult matter for an employee to find private medical treatment. I've had the personal experience, and I'm sure many of the honourable members will have had the experience as well, of having walked into doctors' rooms or the admissions of a hospital and see specific rules relating to injury on duty admissions. We will have also seen that in some cases the medical service provider will make it clear that they will not treat injury on duty patients. We believe that has little to do with the fees that are paid, which are generally in line with what medical aids would pay, if not more generous, but on the administrative burden that's placed on them to be able to claim, as well as the fact that they often have to wait a very long time for their money to be paid to them. We believe that by introducing this amendment to Section 73 and therefore denying providers the choice on how they recover their COID fees, that employers and their injured employees will have probably even greater difficulty obtaining medical services if medical service providers know that payments are going to be reverting back to very long delays. An issue on how this affects the compensation fund, in our view, is that employees may eventually be treated in public facilities, or they might just be referring their medical expenses to their medical aids. That might appear not to be too much of an issue from an administrative point of view on the face of it. Unfortunately, however, in cases of those of treatment in those particular instances, the compensation fund may find it nearly impossible to obtain medical reports. And we'll remember from an earlier slide that an accident is reported by, firstly, the employer, and secondly, verified by the medical report submitted by the treating doctors. If those medical reports don't find their way to the compensation fund because the employee is treated in a public facility, which generally are not particularly efficient at providing medical reports, or if payment is done through a medical aid and therefore a doctor receives his payment via medical aid and doesn't have to wait for payment, or is not expected to produce a medical report in order to receive payment, a medical report might not be produced by him or her either. And that will see claims languishing unresolved because the compensation fund will not be able to obtain the information that it requires in order to adjudicate the claim and pay further benefits. So we thought from a practical point of view, we should highlight what some of the consequences might be in the event that providers are unable to recover as efficiently as they do now through intermediaries the costs of their services. On to the next point of concern, Section 43, which adds Section 70A. I think we indicated earlier on that the introduction of rehabilitation and reintegration into the legislation is something that ought to be welcomed, and we certainly do. However, in our experience, rehabilitation benefits are inadequate or poorly supported. We've raised in our written representation that it's puzzling for us to see the stress that's been placed on rehabilitation and reintegration, yet it's probably been a decade now that we've been asking the Compensation Fund for a position with regard to the payment of services of biokinetic assistants and dietitians, for example, whose services are often called for by the providers of medical services and by the treating physicians who see that the involvement of these types of service providers are important in the rehabilitation and the reintegration of their patients. And yet the position of the fund has typically been, well, we don't have a fee schedule, so we can't pay them and we're not going to pay them, or alternatively, we'll just pay them whatever they're claiming. But there doesn't seem to be a clear strategy, and there certainly isn't a fee schedule against which they can be paid even now as we speak. Also from an institutional point of view, physiotherapists really do struggle in our view to obtain payment, and they're typically a category of provider of medical services who isn't well serviced by intermediaries and have to struggle themselves to obtain payment from the Compensation Fund. In our view, the Compensation Fund must urgently review the regulatory framework for rehabilitation. And I've just...
Next one.
Moving on to the next point, section 52, which amends section 85. Again, it's a topic similar to the previous one. We have no difficulty with the changes to the legislation, but we have very deep concerns with regard to a framework for rebates. Section 85 contains three parts, and the part that's to be amended is the third. The first part rewards employers whose accidents and whose claims costs are more favorable than their peers. The second part allows the Compensation Fund to load or increase the assessment rates of employers whose claims costs and claims frequencies are higher than their peers. And then the third part, which is the one that is to be amended, makes provision for a rebate as opposed to adjustments to assessment rates at individual employer level. However, since 2011, the Compensation Fund has been inconsistent, and we use that word graciously in applying Section 85 discounts, loading and rebates. We therefore suggest that not only Section 85.3, but Sections 85.1 and 2 also are made subject to strict guides, so that we do not see a notice such as I'm going to present on the next page, where the executive essentially suspends the force of a section of the law. So the yellow highlighted section there states that the withdrawal of the implementation of Section 85.1 on reductions with effect 1 March 2021 until further notice. We see this as the suspension of the law pending a decision of the executive, and we see this as not only being irregular, but also unfortunate when viewed in light of the fact that the intention of the executive is to introduce further forms of rebates, and yet the existing forms of rebates and reductions are being suspended, let alone inconsistently applied. So in summary, we would like to see that the ways in which rebates, reductions or loadings are to be applied are subject to regulatory frameworks or some form of rigor. The last point is partly a technical one, but it also raises some issues with regard to privatization. So we've noted here that Section 1 is to be amended by introducing the words "and be." So an employee individually liable means an employee in terms of Section 84.1a and now should read and B is exempt from paying assessments to the compensation fund. We believe it's unfortunate that we're not recognizing the 3 tiers of the various forms of employer, as we've discussed at the commencement of the presentation. And specifically, certain employees exempt from assessment. No assessment in favor of the compensation fund shall be payable in respect of employees in the employ of national, provincial spheres of government, including parliament, provincial legislatures, local authorities, which is the second point, and a municipality, with specific requirements. Now, the issue that we have with employers individually liable is that, as we said earlier, they are self-insured, whereas employers who are exempt from paying assessments includes employers who are insured by the private insurers. The issue arises with subsection 3, which is notwithstanding of 84, notwithstanding the provisions of the section, the Director General may, on application by an employer referred to in subsection 1, permit such employer to pay assessments to the compensation fund in respect of his employees, and thereafter, so the highlighted, the bold component is our issue, and thereafter the provisions of the section shall cease to apply to such an employer. So it appears with the wording as we have it here that if an employer is exempt, and then reverts to the compensation fund, they are no longer permitted to be exempt from paying assessments to the compensation fund. We believe that it's interpreted as such. This might be open to interpretation in another way. But if we consider the fact that the entire class 13, whether they chose to or not, are insured by the RMA, should Section 30 result in privatization of some form, which allows those employers to either choose to go back to be insured by the compensation fund, or to choose to be insured by another private insurance company. One would argue that they lose the right to do so under Section 84.3. It would be unfortunate then if we were to include in the definition of an employer individually liable employers from the private sector. I see that I've run ahead of myself and I've covered all of these points while I was talking. It's therefore incorrect to group these 2 classes of employees together under the banner of employers individually liable. And I see that we've addressed this slide as well, which leads me to the conclusion, which is just to thank everyone. As I said, that we have addressed more than these points, but we have raised what we believe are the more important of the points that we raised in response. So thank you very much for attending and listening, and I'm happy to take questions via the chair.
Thank you very much, Mr. Pivo. Honourable members, there is the presentation. Can I get hands? I see there's one hand now. Any others? Any other hands? Second hand. Any others? Okay, for now, Honorable Mkondo, Honorable Ngabane.
Thanks, Chair, for the opportunity. The presentation is welcome. Chair, in the introduction, the size of the company and the people representing the company was clearly explained, but I did not hear as to exactly what is the mission of this company and whom are they servicing? Are they their beneficiaries are the workers directly, or the employers, or claim administrators, or medical service providers? I did not hear just that. If that can be explained, Chair. Thanks very much.
Thank you, Honorable Mkondo. Honorable Mkabane.
No, thank you so much, Tripisine. I just want also to welcome the presentation by Mr. Pivo. Chair, there are many issues that have been raised around the issues of impracticality for employers and employees in terms of COIDA claims. Amongst the issues that the presenter has mentioned is the impossibility to obtain medical reports from the public facilities. So I'm not an expert in this field, but I just want to understand, because the chair said we should seek clarities. So, Chair, I want to establish whether there was a study that was done, or is it based on what is raising? Is it based on experiences or analysis of both the private and the public facilities? That it is quite impossible to obtain medical reports from the public facilities, because one would then argue that in a nutshell, the presenter is saying the public facilities are inefficient. If then one could then come to a conclusion based on the claim that has been presented before us. So I want to get an indication whether there was a study that was done, or there was an analysis that was done by the organization, or what makes them then to come to this claim that it's quite impossible for them to obtain those medical reports from the public facilities. Secondly, Chair, the issue is that I want to get a clarity on is around the error in reporting earnings that he has mentioned. So what I want to get a clarity on, Chair, is that whether the system does or does not allow the error captured by the person who was capturing the information on the system to be corrected or rectified once identified, because on his practical experiences or items of concerns, that's one of the issues that he raised, that it becomes quite difficult when the error, in terms of reporting earnings, the system does or does not allow the error captured to be rectified once it has been identified. That's what I want to get. Chair, the last one is that he did mention that COIDA system then delays reporting unless aspects of accident or disease are known, e.g. COVID-19 questionnaire, which then results on their processes and submissions or whatever exceeds 7 days. What I want to get, Chair, is that because I used to see the COVID-19 questionnaire, for me it is quite simple, to follow it and to fill up that form. The form that they are using when they are processing the claims, is it different from the questionnaire that we use as the members of the society, or they are using the same COVID-19 questionnaire that we use? Those are the 3 questions, Chair, that I want to get clarity on. Thank you so much.
Thank you, honorable members. Mr. Pivo, I just want to ask this a clarity on the last question that has been asked, but in a different way, is that you said unless all aspects of the claim has been filled in, I may not be quoting that thing, that sentence verbatim. Do you have a problem with that? Of a system that if not everything is filled in, then there is a delay. Do you have a problem, or do you expect a system to just pay out even if there are gaps in terms of the verification form or a system? So I'm asking a question on that matter, but in a different way, in terms of the verification of the claims by the compensation fund. In the absence of other hands, I will then allow you to respond to those questions.
Thank you, Madam Chair. The first question, which is what is our mission, what is our role, who do we service, who we are. Our clients are employers, typically. We also have as clients, to a lesser degree nowadays, although it was different 20 odd years ago, we have amongst our clients the injured employee himself or herself via their legal insurance. So they would approach their legal insurance, such as Scorpion Legal Protection, and they would state that they have a problem with the claim that's not being resolved, and Scorpion Legal Protection would refer the claim to us to look into and to bring it to resolution. So the assistance that we provide employers is administrative. Typically, an employer that employs 1,000 employees or more would have a person or a team of people who would be attending to the claims administration or to the administration around the reporting of earnings and ensuring that they have letters of good standing in order to continue with their business, and that the assessments that are levied are paid on time and the rest of it. So the responsibility that we take upon ourselves is to do the administrative work for them. They effectively outsource the administrative work that they would otherwise have to do. We also guide them to make sure that the work that they do is compliant. So if they are reporting accidents, we make sure that the documentation that's submitted is complete, that the information that's required is complete and accurate, that they don't make mistakes when reporting an accident, so for example, indicating that the earnings by the employee is R1, and then later have to go back and fix it and go through the process of notifying the compensation fund that the information that they provided was inaccurate in the first place and now has to be corrected. So I hope that answers that question. If more information is required on that, I'm happy to replow that ground. The second question that was asked is, excuse me, the second question that was asked was with regard to the difficulty stroke impossibility of obtaining medical reports from the public service. No, we haven't done a formal study, and that's pretty much anecdotal. What we have is, under typical circumstances, the way that we operate is that we will receive notice from a client employer that an injury as an accident has taken place, and we will effectively hold the employer's hand through the process of making sure that the accident is properly reported to the compensation fund. We will then get involved in the work that the employer would typically otherwise have to take upon themselves, which is in some instances to contact the doctor who treated the employee in the first instance and obtain a first medical report. There would also be subsequent reports when the employee is ready to return to work and resume duties. Medical reports would have to indicate that the employee is ready to return to work, is medically fit. If the employee is off work for a period of time exceeding a month, then there would typically be interim or progress medical reports that would have to be obtained from the doctors. Now, anyone who's had dealings with a doctor's rooms will know that the receptionist in the doctor's rooms is very protective. One can't easily get through to the doctor. If the medical reports are available on file, they'll be drawn from the file and they'll be sent to us or to the employer or via the employer. Or they will tell us that their documentation has been uploaded onto the commissioner system and there's no need for us to obtain it. The work that's involved, though, is cumbersome and it's onerous, and it's often dealing with busy people who have better things to do than supply you with medical reports that are a pain in the neck to fill out. And it's a difficult enough job as it is when dealing with providers in the private sector. In the past, prior to electronic submission of documents, and the process as it is in the legislation requires that the provider of medical services actually submits their reports directly to the employer. And the employer vets the documentation to make sure that the information contained in the report is consistent with the information that they have. So, for example, if the employer's witness of the accident was that the employee fell and hurt his or her ankle and might have led to either a sprain or a fracture, the employer would expect to receive a medical report that states that the employee had a sprain or a strain on the one hand or a fracture on the other hand. And the medical report would also give the employer information which would help the employer to determine when to expect the employee back at work. The employer would then pass the documentation onto the compensation fund by post, and included in the medical report would typically be an invoice from the doctor. And as I stated during the presentation, the doctor would typically not be paid unless the medical report was submitted. And in the very early days, the medical report and the invoice were all on one piece of paper. When we look at the process, if the employee is admitted to a public facility, we're obviously now not dealing with the doctor's rooms with the receptionist or two receptionists and a GP or a specialist or two, in which case it's fairly easy to identify the person who's meant to submit the report. You know, contacting a public hospital, a provincial hospital, which could employ thousands of people, and simply obtaining the identity of the person who should have submitted the report, the name of the doctor who would have compiled the report or treated the patient, becomes a difficult job. Those people are also terribly under stress and overworked in our experience. And to get a report from them just becomes considerably more difficult than it is in an already difficult situation of getting a report from somebody in a small doctor's room. So we're not saying that it's an impossible case. We're saying that it is some cases close to impossible. We're not saying it is impossible, but it is considerably more difficult than it is when dealing with the small doctor's rooms. The third question that was asked is with regard to the reporting of errors in earnings. Madam Chair, is it possible for me to hand over to my colleague Ravishnu, whose image is in front of you, and she has intimate knowledge of that, and she could speak to the question of what happens in the event that an employer were to enter something on the system that isn't exactly what they wanted to capture?
Okay, no.
All right, good.
Can we see her face?
Yes, good afternoon. Sorry about that.
Sorry, I need to do something.
What is it? Is there any other gadget that is on?
Let's try this again. I think. Yes. Let's just give this one more time. Good afternoon, Madam Chair and honorable members. Sorry about the interruption. So with regards to the difficulty with the online ROE system, the system is very simple when you look at it. And the page that is displayed allows you to enter the number of working employees and directors receiving a salary
over the 12-month period. And once the earnings are captured for employees and directors and submitted, there's unfortunately extreme delays in having assessments resolved. There are no clear instructions on the page that clearly indicate that no decimal points are allowed or no cents are allowed. So whenever returns are submitted in cases where employers are not familiar with the online system and how it actually works, there are cases where decimal points are added, as Mr. Pivo mentioned earlier on, resulting in assessments that are 100 times or 10 times more than what is expected to be paid for the year. And there has been a government notice as well that has been implemented as of 2016, in which the compensation fund has made it clear that they will not entertain any requests for the revision of earnings, even if the earnings that have been captured incorrectly by accident, or whether earnings have been estimated incorrectly by the compensation fund. If they have not been requested within a 30-day period, it will not be entertained at all, and employers will then be expected to pay these assessments that are 10 times, 20 times, or 50 times the amount of their actual true assessment. And this has also been applied retrospectively, which is becoming even more difficult because the set of requirements from the compensation fund in 2010 are different from the requirements from 2015, 2016, and even at present. So we are experiencing extreme delays in getting these assessments actually corrected, and allowing employers to pay assessments based on their true and actual figures instead of the estimated earnings or the high amount of earnings that have been accidentally declared and are in fact incorrect. And just a second. And on the system as well, once the returns are submitted, it does not allow the employer to correct the earnings that were submitted at all from the end within a 30-day period, or any period for that matter. And there isn't a formal procedure that's actually put in place by the compensation fund to ensure that these returns are correctly processed should an employer require the earnings to be corrected. There is a simple note to say that should the employer inform the compensation fund that the earnings that have been declared are incorrect, the compensation fund should look into correcting the earnings to the actual and true figures. But we are still struggling with a lot of delays due to changes in the requirements and notices that have been put in place, banning employers from actually having the earnings corrected in any form or any manner, let alone having it corrected online. If I have misunderstood the question, or if there's any additional information you do require on the point, please feel free to address them at any point.
Are there any comments, honorable members? Honorable Mkondo, is that an old hand or is it a follow-up?
It's an old hand. I'm sorry, Chair.
Oh, okay.
Thank you. The fourth question we have, sorry, Madam Chair, may I continue?
Yes, you may. You may continue.
The fourth question is the information that's required online. Is it any different from what's filled in on the COVID-19 questionnaire, and in what way? I'm going to try and answer it briefly, but I'd like to ask my colleague under Johan de Bruyn's name, who's Corrie, to fill in if I've left anything out of importance, please. The information that's asked for, no, is not any different. The issue, and Madam Chair, in the answer, I think I speak also to your question, and that is the question that you raised are, do we have any difficulty with providing all the information that's required? And if we do, then what would that be based on? Surely we don't expect the Compensation Commissioner to adjudicate on a claim or make a decision on a claim or pay benefits without all information.
Sorry for that, Honorable Mkondo. Can you mute, please?
The issue that we have is a fairly subtle and administrative distinction, Madam Chair, and that is that there are two steps in our view in the process of bringing a claim to the Commissioner's attention and for him to apply his mind to the facts of the claim. The Act makes provision for if you like, two separate processes that are certainly linked but are separable. The first is the reporting of an accident, and the second is the adjudicating of the claim. Now, the reporting of an accident has effectively brings to the Commissioner's attention the fact that an accident has taken place. The Commissioner requires that information on an urgent basis for a variety of reasons, some of them practical and some of them legislative. One of the practical considerations is that the employee, the claim itself is similar to the concept that you would have if you're reporting, let's say, a claim to your short-term insurance company. Until they know about the claim, they don't know what to do with the documentation or the information that might flow to them from other parties involved in the claim or other information that might relate to the claim. So if an employer reports an accident to the compensation fund late, and in the meantime, there's medical reports and other documentation that flow from other involved parties, the Commissioner has nothing to relate this back to. So in reporting a claim to the Commissioner's office, you place the Commissioner in a position where he knows of an incident that has taken place involving a particular employee and a particular employer on a particular date. So once the report has taken place, the Commissioner is aware of the fact that employee A was injured on the 1st of January 2021, and employee A works for employer Z. Incidentally, the Commissioner at present doesn't have a system, in fact, nor do any of the insurers in this country have a system which links a particular employer to a particular employee and vice versa. So when an employer reports his workforce's earnings to the compensation fund on an annual basis, he doesn't include also the names and identity numbers of all of his employees. Once the Commissioner has that information and the claim, in our view, has been reported, the Commissioner can, in those instances, refer to that particular incident with a reference number. And that reference number has become something of enormous value to all players in the industry, and especially to providers of medical services. It places them in a position that when they submit their medical reports, when they submit their invoices for medical treatment, they can refer them back to that claim number, with the knowledge that at least it has been reported that the Commissioner has record of it. At that point, there is no intention or understanding that the Commissioner would necessarily apply his mind to the information that's provided, but simply that the Commissioner is being made aware of. And in our view, in order to do that, all that's really required is the identity of the employee, the identity of the employer, and the date of accident, or if there have been 2 accidents on the same day or more, the time of the accident. If further information is required, of course, the information must be supplied, and the information should be supplied, and with the use of computer systems, very easily tracked to inform the employer that although the accident has been reported, it hasn't been reported in full. So if we go back to the COVID-19 situation, to inform the Commissioner that your employee has been off work, you're not exactly sure whether what the long-term situation is going to be. You can't tell the Commissioner at this particular point whether the employees that he was or she was exposed to, the customers or the patients that the employee was exposed to are COVID-19 positive, but you can say that the employee was diagnosed as positive, you can say that the employee is off work, and you can say that it appears that the employee was exposed to COVID-19 in the workplace in some form or another, or the employee alleges that he or she was. The Commissioner will obviously not be considering liability at that point or considering paying benefits at that point until such time as all the information has been supplied. So we see it as two separate processes, the one of just notifying the commissioner that there is an accident and you have an obligation to report it, and you've done so. And the further is to meet all the documentary requirements and all the information requirements, which is providing all subsequent information. A typical example, which COVID-19 is maybe not a particularly good one of, is an employee that's injured in a motor vehicle accident. If an employee is traveling from point A to point B, and point A could be one office, and point B could be the site or a factory or another office, and the employee is injured, it could be quite some time before one gets all the information about the other parties in the accident, assuming that there were. One, for example, might not have the police case number. You might not have the registration details of the other vehicles. The difficulty with the way in which the reporting process currently works is that before the commissioner will acknowledge that the accident has been reported to him, he requires all that information to be provided up front, or a situation similar to that. So we would like to see that being separated, notifying the commissioner on one hand that your employee was traveling or was involved in a motor vehicle accident. It appears that it was for business purposes. More information will follow. However, we are being prevented, and employers are being prevented from reporting the claim until a much wider group of information or scope of information is provided. And one would like to see that a differentiation is made between the two. And I hope that I haven't provided too many words and not answered the question in the process, Madam Chair.
In fact, it's a question which I would have thought that it won't be, don't need so many words to respond to, because it's my understanding, and I'm putting it to you, that every institution, workplace, company has got policies and rules on how to address ABCD. And you have said in your presentation, it's only that you can't go back to that unless all aspects of are filled in. They are to be filled in. Why is it that you would prefer? That's a question. Why would you prefer the compensation fund to do or to conduct its business in a manner that you think that it's much easier for you? Why would you do you think it's a correct? It's correct for anybody outside the compensation fund to, should I use a hard word, to dictate to the compensation fund how they should process, how should they process their claims, because they have got a responsibility of ensuring that ABC. But why is it that you would prefer or you would like to dictate to the compensation fund? Do you think it's fair? Do you think that will be a good way of running any company or an institution, to be forever dictated by the outside people on how you are to process, on how your systems are to be structured in a manner that you think as the leader of that company, it's correct, because you have got that responsibility as any leader?
The provisions of the law, Madam Chair, are that the Compensation Commissioner or Director General under the current legislation has rights to investigate a claim and call for information in any way that he chooses. And we see that as a very important right. And the importance for the compensation fund to apply their minds in deciding liability is in my view, is without question. I'm a little taken aback by the question. I didn't realize that we were to come across as prescribing or attempting to prescribe to the fund or the compensation fund, which I wouldn't be wanting to do. We did see, however, that in the context of the penalties that apply in the event of the report not being submitted in the prescribed form within 7 days, that that cognizance should be taken of the fact that the practical considerations around providing information that's required not only for the purposes of reporting, but for further decision-making down the line, places we see an unfair responsibility, and a responsibility that in many cases, especially with very large employers, is difficult to meet. And a solution that we saw, which is in our view not difficult to implement, is to distinguish between the reporting, which doesn't involve decisions and doesn't involve the commissioner applying his mind to the facts at hand, becomes a different step from the step of supplying information that's required for decision making. If I can use the motor vehicle accident as an example, the compensation, the process has been at one point where a notice would be supplied to indicate that an accident had taken place, and subsequently the employer would be asked for the information to be supplied at a later date. My colleague Corey has just put a note on my desk, and she's very practical, and she simply said that the difficulty that's faced, and I think I'm talking around the point and losing focus of the fact, is that under current circumstances, we can't get a claim number. An employer can't get a claim number or a reference number which indicates that an accident has been reported. And without a claim number, it's very difficult to get treatment for an injured employee. And we would like to see that. We would like to see that issue, as well as acknowledging the fact that the Commission has been made aware of an accident, is something that's separated from the adjudication process.
Thank you very much. If there are no more questions of clarity, we'd like to thank you very much, Mr. Pivo, and your partner. You can still, as we do to all presenters, that you can be invited to be to be part of the next presentation. Thank you very much. Can we get the next presenter? I have been reported, honorable members, that we were going to have a presenter from Wits who has apologized. Can I then check with Mr. Ngobu, who is then coming in?
Thank you, Chairperson. The next presenter is Mr. Hughes from the Injured Workers Action Group, IWAG. Thank you. Thank you, Chair.
Thank you. Thank you very much. Are they in? Mr. Ngobo?
Yes, Chair. Yes, Chair. I was informed he is ready.
Mr. Tim Hughes. Is it Mr.? All right, sir. Why is he not? Oh, there is.
I wonder if you can hear me.
I can hear you. But I want to see your face.
Chair, is that clear? My apologies. Is that clearer now?
Yes, you are.
Thank you very much. My apologies, Chair. Nice to see you. And thank you so much for the opportunity, which we look forward to. Thanks to you. Thanks to the honourable members. May I also add our thanks as IWAG, the Injured Workers Action Group, to your staff. Just the way that they have facilitated these hearings, our submissions, for their flexibility. They've been tremendously communicative, and without them, this wouldn't be possible. So we'd like to thank them very, very much indeed for that as well. Chair, if I may, I want to keep things relatively short. We're getting to the end of the presentations, I know. We wanted to do two things today. Firstly, with your permission, could we show you, the members, a short video that IWAG has put together, which allows our members to speak directly to their issues of concern? And if we can show that video, we'd like just to follow up with a quick PowerPoint presentation and then open ourselves up to questions if possible. Would that be in order?
Very much in order.
Oh, thank you so much, Chair. Thank you. I'll try and use my relative incompetence and share what I can. Just bear with me for a second and let's see if we can get this video up.
Honourable members of the Employment and Labour Committee, we thank you very much on behalf of IWAG, the Injured Workers Action Group, for the opportunity to address you today on the challenges of the COIDA bill and in particular the problems of Section 43.4. You will have heard from our members, be they worker organisations, employers, medical service providers, hospitals, a whole range of supporters. I mean, IWAG itself has the support of some 4 million people. That Section 43.4 is an irrational, unnecessary and potentially very, very harmful section of what otherwise is a very laudable bill. We are delighted that domestic workers have been included in the bill. But those rights will be abrogated if Section 43.4 is passed into law. We believe we have made a very strong case that Section 43.4 is irrational, illogical, untested, impractical, and will have dire consequences. So we've invited a range of our supporters to talk to you today about their particular issues, about Section 43.4, and to make the case for the removal of Section 43.4. Please listen to their authentic voices. It is their true stories. It's what they experience. And please bear in mind too, none of them have been consulted on this bill. None of them was consulted on the socio-economic impact assessment. This is their first opportunity to address you and to protect their rights.
The compensation fund has become structurally and operationally entirely dysfunctional. The only aspect of the fund still functioning is where there's involvement of third-party administrators. The proposed amendment to Section 43 seeks to abolish the function of third-party administrators. This abolishment of Section 43 will undermine the object of the fund, namely to treat or have injured workers treated and to get them back to work as soon as possible. Injured workers, on the other hand, will be severely prejudiced by this amendment. Simply because private practices, medical practitioners, will simply refuse to treat them unless they will be assured of being paid for their services, which in the case of the abolishment of Section 43 will no longer be the case.
I am opposed to the introduction of Section 43 because as domestic workers, we have fought for many years for the right to access quality medical care under compensation fund. And I'm very pleased that the government is introducing legislation that will make this a reality for our vulnerable and always overlooked sector. But our inclusion will only have value if the system works. If the government removes the areas of the fund that actually work well, they will effectively be undermining the level of care that domestic workers are being promised and remove the true benefit of being a beneficiary. It is for this reason that I oppose to the inclusion of Section 43 of COIDA Amendment Bill.
For us, Section 43 is very problematic. Medical service providers do treat patients injured on duty immediately, but it's important to understand that some of us wait up to 2 years on average or even longer before we are paid by the compensation fund. This is mainly due to the systemic failure of both the IT systems and administration of the fund. It is unrealistic to expect a physiotherapist, a medical doctor, or even a small practice to wait this long for payment. Again, given the fund's dysfunction, medical service providers have for the past 20 years been making use of the services of third-party administrators. These administrators perform a critical service in helping the medical profession navigate the fund's systems to secure payment for medical services rendered to these injured workers. These third-party administrators also play a critical role in the sustainability of medical practices. Again, important to notice that they pay the medical service providers upfront for their invoices. Without sessions, the pool of medical service providers caring for the injured on-duty patients will decrease significantly, which is in nobody's interest, especially injured workers. It's also important to note that domestic workers will now get on board and fall under this compensation fund. There are expectations being created that they will receive services from private sector and don't need to go directly to the public sector. This is, as I've already said, expectations that's not going to realize if the current amendment to this bill is not removed. From SAMA's side, we are asking that the amendment must be removed from a bill. There is no justification for it.
Now, if you look at the injury on duty, this proposed COIDA amendment bill, we have opposed it basically for two reasons. One is we feel that when an injured worker presents himself after an incident or an accident, the member company fills in the WCL2 form and then refers this injured employee to the nearest medical practitioner for the first report. Then the employer tries to fill in these details of the incident on the COID and Easy Comp system of the compensation fund, which unfortunately is not user-friendly, is prone to frequent system downtime, and is generally a difficult system on which to capture information easily and quickly. The medical service providers have provided assistance to the injured worker, even though the claim is not as yet registered on the EasyCom system, and then deal with a third-party vendor to pay them upfront, allowing the third party to claim from the compensation fund which may take either months or sometimes even years to process each claim. So if this medical service provider refers the patient to a hospital, the hospital is...
Mr. Tim?
Chair?
There's a hand from a member. Can I just try to establish why there is a hand?
Of course, Chair. Thank you.
Honorable Nonsele.
Thank you, Honorable Chair, and sorry for the disturbance to the presenting member. I'm just taking terms of the roles. Are we supposed to listen to recorded view?
I missed your question, Honorable Nonsele.
Of ordinary South Africans, including those who have already participated in this exercise. Okay, just a second. Yes, can you hear me, Chair, now?
Yes, I can hear you.
Can you hear me now?
I can hear you.
Okay, yes. What I'm asking, yes, okay. Let me rules allow us to allow for a presentation of this nature where stakeholders bring in recorded views that cannot be engaged. Those views, in fact, that are recorded include participants who have already made their views to this process, like Sama. Sama has already spoken here, but of major concern to me is that these are views expressed that we cannot even engage because they are recorded. So I wanted to check from you for a ruling on this matter. Thank you, Chair.
No, thank you, Honorable Nonsele. One, these are public hearings. And in the public hearings, we are to listen to people that are making presentations. What I think first, because myself also, I was just taken aback a little bit because Sama has made its own presentation. So I'm not quite sure why again now it is back. But secondly, can we check from Mr. Tim that questions are going to be asked of clarity? Who is going to respond to those questions? Because I understand your question, Honorable Nansari. The only challenge is that now we're in this, we're using virtual. We can't be, because if they were under one roof, they would then speak because they are coming from this organization, and this organization would have then structured its presentation in this way. But now I think I understand your point, which myself I've been trying to understand who is going to respond, Mr. Tim, to questions of clarity.
Thank you very much, Chair.
Because the reason why we are asking this is that it would have been fair from your side if you would have told us that this is the way that you are going to make your presentation, so that we are able to check and consult how best we can allow questions of clarity. Because I don't want you to say you have been prejudiced in these hearings, you were never given time to make presentation, but who is going to answer questions from these presentations? And some are presented last week. It can't be double dipping from some.
Thank you, Chair. As IWAG, we are an umbrella body with members from workers' organizations, medical fraternity, employer bodies. And this video was put together quite recently, that is true, but prior to the hearings, and it represents the views of our members. There are a lot of views on the video that haven't had the opportunity to present to the committee and honourable members, including the current one and the next one or two. Chair, I will do my absolute best to answer any questions on behalf of IWAG. Of course, if there are questions that I can't answer, don't have the professional competence or skill, please permit me to note them down, go back to those individual members and convey those questions to them to get a rapid turnaround to you to answer those questions. So my apologies if it seems as if we're double dipping, that wasn't the intention. The intention was to try and convey the viewpoint of IWAG members. So my apologies if it's come across the wrong way.
Honorable members, that is the response. Really, we are put now. We are. Can I just get Honorable Nonsale, that is the response. Can I get the other views of other members?
Okay, I'll come later.
I don't see any other hand. I don't want it to.
Can I make a suggestion, Chair?
Yes, Honorable Nonsale.
My suggestion, Chair, is that can't we, Mr. Tim Hughes, with due respect, start with his own presentation, and then we can then have these visuals as an addition to his presentation, because at least we can engage with his own presentation, so that we don't disadvantage him, so that when we listen here, it would be in addition to what he in fact has presented. Thank you, Chair.
Thank you, Honorable Nonsale. That is a suggestion from Honorable Nonsale, or a proposal on the way of us dealing with this presentation. Any comment, Honorable members? Honorable Mkondo, I see Honorable Kado. Which other hand is there? It's Honorable Kado, Honorable Mkondo. Whose other hand? I can't see because my screen is. Who's the other one who wants to speak? Outside the two. After Honorable, oh, okay, it's Honorable Kado, Honorable Mkondo. Honorable Kado.
Thanks, Chair. I think that in its nature, IWAG is an action group that represents various role players. It's an umbrella body. So from my point of view, I think it's quite interesting to get the perspectives of the members of the umbrella body, which are reflected in the video. So I would be supportive of continuing to watch the video, but if the feeling on the committee is that we should cut to the chase and get to the presentation first and then come back to the video afterwards, I would be happy with that as a course of action too. Thank you.
Honorable Mkondo.
Chair, I support the idea that we start with the presentation and then the video will come thereafter. Thanks.
Thank you, honorable members. That's why I wanted to give members so that I don't just take a decision on my own, because that was my initial thing, which I thought that, Mr. Tim, can you please give us your presentation, and then the video will then come after that. Thank you very much. Over to you, Mr. Tim.
Thank you, Chair. Chair, is that clear? I just wanted to make sure, being technically challenged, that you're stretching my abilities here. Is that clear for everyone?
Clear. It's clear to everyone.
Okay, fantastic. Thank you very, very much indeed. All right, so our focus of the presentation is on section 43.4 of the bill, acknowledging that we are highly supportive of the bill, and in particular, of course, the inclusion of domestic workers under the purview of the bill. Our contention is captured principally in this slide, and it's a very, very short presentation. I think we have about 8 slides only. So to reiterate, we acknowledge the breakthrough through the Constitutional Court of our domestic workers being included under the COIDA Act, which is most welcome. Our concern is Section 43.4 of the bill, as it currently stands, will prohibit medical service providers from ceding their claims for payment by the compensation fund. Our concern is that this would lead consequentially to third-party administrators who we know assist the medical fraternity with administration and funding, no longer being able to provide this service in the absence of financial and legal security because they don't have the cession of the claim. We believe that the result of this is likely to be that thousands of medical service providers will lose their constitutional rights, principally their right of property, and be forced to do their own administration and to claim directly and individually from the compensation fund. We believe without the support and benefits of third-party administrators and funding, it is possible that medical service providers may choose not to treat injured on duty workers or patients. There's a possibility and there's a risk, and we believe it's a significant risk. We then, as IWAG, looked very carefully at the reasons or the stated reasons or the justification for the introduction of Section 43.4, Section 43.4 of the bill. So we were looking as hard as we could. We looked at the records of Parliament, media, etc. And what we saw was the justification appeared to hinge on a couple of issues. At some time or another, the Minister, Director General, the Commissioner, and even the Chief Director have indicated either in Parliament or publicly or in the media or in front of yourselves, honourable members, that 43.4 would lead to the removal of the need to deal with third parties. This is a stated objective. But what is interesting to us and perplexing to us is that we've never been able to find the justification or the evidence or the empirical facts or the rationale or any justifiable reasons for doing so. Why would you remove these third-party funders? We then looked very carefully at the bill's socioeconomic impact assessment, and we couldn't find any reason or justification within that socioeconomic impact assessment, which we thought would be the basis for the inclusion of 43.4. We also saw that there was mention now and again, and there's repeated mention actually, of objective or justification to eliminate fraud and corruption between service providers, such as third-party administrators, and the compensation fund. But what we couldn't find, honourable members, honourable chair and honourable members, we couldn't find any evidence, any criminal cases, any cases of fraud, any prosecutions between or against these third-party funders and the compensation fund. So we couldn't find any cases where the fund, the commissioner or the DG or the minister had taken any of these third-party pre-funders to court because of their engagement in fraud or corruption. So we couldn't see. We saw cases of corruption or fraud rather within the fund and between other entities, but not between these third parties or these pre-funding third parties as well. What we found, looking at it, was that the way that these pre-funders, these third-party pre-funders operate, is it's very much in their interest, it seems, to clean up any claims. In other words, only accepting a claim that is clean, that is appropriate to the tariff. And in fact, it looked as if, from the evidence that we were seeing, as if these third-party administrators, these pre-funders, were actually probably cleaning up claims and identifying cases of fraud or potential fraud or the threat of fraud before they go to the fund. So what we were seeing rather is that these third-party funders were actually assisting the fund in not permitting fraudulent or attempted fraudulent claims to go to the fund, which is an interesting point. So we then said, well, do these pre-funders, third-party pre-funders, do they cost the fund anything? Is there a cost against the fund? And we established that is not the case. So the only claim that goes to the fund is that which is due in terms of the tariff. We were principally concerned about whether or not this is a cost, or these pre-funding third parties cost workers. I mean, is it do the workers get paid less? Is there less compensation, etc., by virtue of a medical service provider dealing with them? And there isn't. We established that there's no cost to workers. There's no cost to employers in this particular instance. There's clearly no cost to the fund, but the relationship is between the medical service provider and these administrators who assist them. In other words, it's a sort of a free working business decision that they make to have these third-party administrators help them with putting the claim together and indeed getting paid quite quickly, given the issues that we've seen relating to some of the problems in the delays of medical service providers being paid by the fund. So we looked at procedural issues as well, Chair and honourable members. We went to the socio-economic impact assessment, and you are far more expert than I on these issues, given your position as parliamentarians. But what we established was that Cabinet does require a socio-economic impact assessment to be conducted for any piece of legislation. You know that inside out, but this is what we were discovering. But what we saw in the COIDA bill SEER is that it doesn't pass muster. It's not really fit for purpose. It doesn't really help us understand the rationale and the reasoning and the justification for some of the issues within the bill as well. So we saw that the SEER itself, the socioeconomic impact assessment, dates back to 2015, which is an extraordinary period, a lag between the SEER being done and the bill being introduced. So it's 6 years old. Of course, it was conducted under the aegis or the auspices of a different minister, and indeed a different government, a different cabinet, and under the presidency of Honorable Jacob Zuma. Interestingly, technically too, it was written whilst the old Umashluku system was in operation. Now, as we've heard, that system was replaced effectively in October 2019 by the COMP-EASY system. So we're trying to understand as well how the socioeconomic impact assessment then, 6 years ago, is fit for purpose or can tell us or assist us with the bill today, and indeed the COMP-EASY system as well. What was also quite extraordinary to us was that the SEER was written in just 2 months. And we looked at other examples, such as the NHI, we looked at alcohol, we looked at various other socioeconomic impact assessments that we could find as well. And for the SEER to be written in 2 months seemed to be extraordinarily quick and extraordinarily short period of time. And it made us worried or concerned that perhaps all significant parties or all impacted parties, which is what the SEER had not been consulted. And that raised an alarm for us as well. We then discovered that the socioeconomic impact assessment didn't take the time to interview medical service providers. I think it was this morning, wasn't it, Chair, earlier on today, that was it HASA? Yes, it was HASA, I think, that said that they had not been consulted in the socioeconomic impact assessment. I think it was the same case with the South African Medical Association as well. So, the very people that this may affect had not been interviewed or considered in the socioeconomic impact assessment. We don't see evidence of workers per se being interviewed in the SEER as well, or taken into consideration. And by definition, of course, at that time, regrettably, domestic workers were not interviewed. So whether that was, UDWOS or SADU, domestic workers were not being interviewed or taken into account in terms of the socioeconomic impact assessment. Thirdly, these third-party administrators, the pre-funders, they also haven't been interviewed, or they were not interviewed or taken into account when the SEER was conducted as well. So that very clause, that 43.4, that effectively would remove their services, they had not been interviewed about it. We also couldn't find, Chair, any evidence of the banks being interviewed or considered in the socioeconomic impact assessment. So all in all, looking at this here, we conclude from our perspective that on the evidence, the socioeconomic impact assessment is inadequate and is not fit for purpose. Chair, it is very much your purview and your committee to consider whether or not this is fundamental to the bill, and we leave that with you. But from our perspective, we found some very considerable inadequacies with the socioeconomic impact assessment. And having listened to some of the questions that were being raised by honourable members over the past week, it seems to me that a good socioeconomic impact assessment would answer those questions, or try and answer those questions. In other words, how many people would 43.4 affect? How many employers would it affect? How many hospitals would it affect? How many workers would it affect? How many medical service providers would it affect? Unfortunately, we don't have that evidence or that data within the socioeconomic impact assessment itself, which I think is regrettable, and it means that we would be questioning of the credence, the credibility of the bill itself, which is a great pity. Chair, I know that, and members, that a number of learned people have questioned the constitutionality of 43.4, and far be it for me to reiterate in any detail what these concerns are, but we too have these concerns about the constitutionality, the legality, and the rationality of 43.4. We do think, we are of the view that 43.4 violates or is challengeable at least on 3 grounds. That is to say, Section 25 of the Constitution, the right to property; Section 22, the freedom of trade, occupation, and profession within the Constitution; and Section 34, the right of access to the courts as well. I know these issues have been covered in some detail, so I wouldn't begin to venture to go into them in any level of detail, but I've got a little pack of information here if we want to go into that into any more detail. We do think that the bill is open to constitutional challenge. We also know that the Honourable Committee, the committee in toto, it has to apply itself in terms of its legislative and oversight work in terms of the constitutionality of any bill that's taken as read. It is also something we know that the President would have to look at in terms of either signing the bill into law or not, would be the constitutionality of the bill. So there's a serious question mark about the constitutionality of 43. We are not in a position to speak for...
Mr. Tim, can you raise your volume? At times you become soft for me.
I've done so, Chair, and my apologies. I must be muffling and muttering. My apologies. I hope that's slightly better. Good. Obviously, a major concern that's been coming out over the past week is this impact of 43.4 on medical service providers. It goes without saying that these are our frontline workers, that they're working under terrible COVID conditions. They're under pressure in the public and the private sector. But it's also the case, it's becoming quite clear as well that as medical service providers, they are exercising their rights to use the services of third-party administrators and funders to assist their practices. This goes to new practices, newly established practices, practices in rural areas, urban areas, working class areas, as much as it does in other areas. It's a facility that medical service providers use so that they can focus on their patients. And they're already under a huge amount of pressure, as we know, because of COVID. It's become quite clear, I think, that they make this choice to save them time and to improve their cash flow. I think there was a presentation, was it last week, indicating how long claims are taking, and we're not here to castigate the fund. That's not what we're trying to do. The data would seem to suggest that the fund is taking on average a long time to pay medical service providers. I think there was one indication that the average was 349 days, up to 420 days, or perhaps 220 days. it seems to be the pattern that the fund is taking a long time to pay medical service providers, and medical service providers use these third-party administrators as well. Now, 43.4 removes that choice. It removes their right to do so. And we think that that would have two consequences. Number one, it may actually turn certain practices to becoming insolvent, to go out of business, to not being able to continue operating or to continue their business without getting the funding that is required to run their practices. And we believe that if that is the case, either they stop treating workers or they go out of business, that in our country today, that would be catastrophic and unnecessary too. There was talk earlier, Honourable Chair and members, about the role of employers, and there was some very interesting discussion. And I learned a lot from that discussion, from the earlier presentation about employers and some of the issues there. Our figures taken from the last report, we saw the figure of 12 billion made earlier. I saw the figure of just over 11 billion. So we know that compliant employers are contributing some 11 billion to the fund each year. And they do this to be compliant, to make sure, one hopes and one assumes, to make sure that workers enjoy the rights that they are due under the COIDA Act. The concern is that if medical service providers stop treating injured workers due to 43.4, employers themselves will be contributing to a fund and a benefit that workers can no longer make use of. And there was that discussion in previous presentations too, so I'm merely now coincidentally repeating what appears to be a consensus view or some degree of consensus as well. There's also the argument that, look, if workers are not being treated, if they're not getting the quality healthcare they're entitled to, they may then be forced to go to public health facilities. And we know that places pressure on those public health facilities. And we know that workers may not possibly receive the treatment that they are due, the quality treatment or the timely treatment that they are due. And if that's the case, then the possibility of them being delayed back at work is problematical. And you know, workers were already at a huge amount of unemployment in our country, and workers being off work and not getting back to work is a terrible cost to our economy, a cost to their families, and of course, a cost to employers and workers. Well, I've pretty much got to the end of my presentation, Honourable Chair and Honourable members, and it was really just to conclude with a thought on a big picture matter. And yes, IWAG is pleading with the committee to please reconsider or consider 43.4. And we're asking honourable members to exercise their very considerable oversight, and in this instance, legislative powers, about 43.4. We're asking you, of course, to protect our workers, to protect our medical practitioners, and to protect our fragile economy. And I wrote down a note just before we started, and I guess it was the big picture question. And it's a question I asked myself, and I would just open it up to the chair and to the members, is can we see any benefit to workers, medical service providers, employers, or the economy of section 43.4? And from the IWAG perspective, we see no benefit to it at all. What we do see is very great risk, which I think we've demonstrated today and the other presentations have demonstrated. So our plea to you, Chair, to members of the committee, in addition to thanking you, is to consider 43.4 very, very seriously. And our wish, our desire, our plea is for you to exercise your powers and remove section 43.4 from the COIDA bill. I thank you very much for the time.
Thank you very much. Thank you very much, honourable members. Questions of clarity. I see one hand. I don't know whether it's a second hand. Can we take those hands for now? It will be Honourable Kado, Honourable Mkondo.
Thank you, Chair. And thank you too for the presentation. I think you've made your points around 43.4 very well and explicit and compellingly. I wanted to ask you this. Obviously, one of the big selling points of this amendment bill is the inclusion of domestic workers. And I wondered if you could spell out or clarify for us as a committee the connection between the inclusion of domestic workers as a new category of claimants and 43.4, which you've spent a good deal of time discussing. So in other words, my curiosity is around the effect of 43.4 and domestic workers taken together. Perhaps you could tell us whether IWAG represents any domestic workers unions and whether you've had any engagements with representatives of that sector on the bill and what it would mean for them, the issues raised by 43 and 43.4 in particular. Thanks.
Thank you, Honorable Kado. Honorable Mkondo, are you still on the floor?
Yeah, yes, Chair.
Over to you.
Thanks, Chair. I thank the presentation from Mr. Hugh. Chair, the clarity that I would love to get from Mr. Hughes is that does it mean, according to the Injured Workers Action Group, even after the inclusion of the domestic workers as beneficiaries in the COID, they don't see any changes that have to be effected to the COIDA, the act itself? Are they saying to us, yes, include them, you can make changes on that side, but with the implementation part of the bill, there is nothing that needs to be changed. There is nothing that needs to be improved. Is that what this presentation is telling us? Even presentations before this one, Chair, they keep on reminding us that if an engine is running, there is no need to replace that engine. But then if the engine there is more work added to that engine to perform, are they saying still there isn't nothing that must be done to the engine, even maybe to service it or to overhaul it? Is that what they are trying to tell us? Thanks, Chair.
Thank you, Honorable Mkonto. Honorable Nonsele.
Thank you, Honorable Chair. I have a serious connection problems. So I'll leave my video off because I've been getting on and off.
Thank you.
If I repeat questions that have been made, you will forgive me. You get it? Am I audible, Chair?
Yes, you are.
My question, Chair, is that the question of SIA. Can you hear me?
Yes, we can hear you, Honorable Nonsele.
Thank you, Chair. There is this notion, Chair, around the impact assessment that Mr. Hughes says it was in fact done 6 years ago and is not consistent with the current conditions. And he goes on to make an example about domestic workers. The question of clarity is whether, for instance, is it in fact implying by extension that domestic workers are not ready to be in fact to have those rights extended to them in terms of the COIDA Act or bill. That's the first one. The second one relates to also, again, on the impact assessment relating to the other areas, that is the stakeholders within the health sector, like, for instance, SAMA and others. The question again is whether, for instance, he implies that those sectors would still, in fact, would want to talk to issues relating to impact assessment, or the impact assessment does not take into account their views. And the question, therefore, would be, what would be his proposal on how to remedy what he thinks has been an omission with regard to the process? Thank you, Honorable Chair.
Thank you, Honorable Nonsele. My question of clarity is to ask Mr. Hugh if my understanding is that this is not the first leg of the bill. This is the second, or should I say, the second leg of the bill. The bill starts in cabinet. And after then the bill has all the things, the department will then ask, as we are doing now, in fact, the department will invite communities, institutions, whoever has got an interest to input on what then they are putting forward as the amendment. Have you done that? I'm raising that because of your questions of the socio-economic impact. Because it's the process that doesn't start here. It's the process that starts in cabinet. And therefore, have you then asked the department
to criticize anyone? It would seem that the fund has challenges. It would be logical, we would submit, that the addition of 1 million new workers through 1 million employers, and remember that I suppose it is the case, isn't it, that it's unusual in domestic work that you may have a domestic worker working for 2, 3, sometimes 5 people. So there are some complications here with respect to how is this going to work, that we have 1 million new workers, but actually we may have a lot more employers than we previously had just because of those complications. It may also be the case that, employers don't have the wherewithal, the skill, perhaps not all of them have the interest, some of them may not have the time, some of them may not care enough, some of them may be somewhat dubious in their own, as it were, their own employment practices. So there requires an element of education for domestic workers to really realize their rights under the fund. So we've got employers now making contributions, but think of a situation, Honourable, where a domestic worker perhaps strains their back at employer A, and that gets complicated by a fall with employer B. I honestly don't know how that claim would be processed. What I do submit is it complicates matters, and I think it will complicate matters for the fund. And so it worries me that where the COMP-EASY system is far from perfect, and I think everyone has agreed that the system is not perfect, perhaps there is never a perfect system. I just find that if you look at it, the probability that the complications and the challenges that the fund is going to be confronted with by 1 million new workers and possibly, even more employers not knowing the ropes could be very, very complicated indeed. And it may result in the fact that, if medical service providers are not able to cede these claims over to an administrator and aggregate them, it concerns us that perhaps the domestic worker will not get their due. It concerns us that the fund may not be able to administer all these claims. It concerns us that the payments may be even more delayed. It's hypothetical and it's speculative. But what would help is if we could just run, in a socioeconomic impact assessment, could we run some numbers? Could we run some scenarios? There are some really, really, smart people in Parliament. There are content advisors. There are analysts at universities. There are think tanks. There are union advisors. There are employer bodies, etc. We could possibly come together and go, let's run a hypothetical. What do we really need? What happens under this claim scenario? We've got a million new workers and employers. Let's just see what the impact could be before, and I'm not asking that this should delay the inclusion of workers, not at all, because I believe those regulations may have already been published, which is great. I'm just looking at the practicalities of that. And to some extent, I think it does relate to Honourable Mkonto's question, if I may say, and please excuse me, I haven't answered the question properly. I think Honourable Mkonto's question was to say, well, are we saying, domestic workers, there should be no change to this bill, or does it require changes? Honourable, I think it requires an awful lot of work, but concerted work by the department, by employers, by trade unions, by ourselves, by the media, by think tanks, etc., to ensure that workers, domestic workers, can realise their rights under the bill. And I believe that we need to look very, very carefully at explaining to these newly empowered workers who are realizing their constitutional rights, what are those rights? How do they realize those rights? How can they not initiate a claim, but if they're injured at work, what do they do? What do they do when they fall over on a slippery floor? What do they do when they cut themselves at a kitchen? How do they deal with the employer? And then likewise, what does the employer do? How do they begin to, as it were, lodge an injury on duty claim? And then how do we work with medical service providers to make sure that people do realize those rights? So I'm deeply concerned that the bill may be fit for purpose in terms of domestic workers. I don't think it's fit for purpose in terms of 43.4. I think, sadly, we have an awful lot of work to do to bring what is a legal instrument into practical reality so people can realize their rights. And I think we've got an enormous amount of work in this country, the department and others, to try and educate people and bring them up to speed as to how we realize those rights as well. I think Honourable Nonseli was questioned as to whether or not I was saying that domestic workers are not ready, and because of my reference to the absence of consideration of domestic workers in the socio-economic impact assessment. Honourable, the reverse is true. The absolute opposite is true. There's even been some claims, as you know, that domestic workers should be able to backdate claims for injuries as well. I spent a lot of time as a youngster working with trade union movements underground, as it were, researching community health research group, industrial health research group, general workers union, commercial workers, chemical workers industrial union, paper printing wood and allied workers union, Kupana Kimatla. Of anyone, I believe that domestic workers must be part of this process. And it is regrettable that the socioeconomic impact assessment didn't even consider them. And even to today, I'm not sure that domestic workers have been taken into account. They've been asked to participate in this process and as were empowered by the department, by Parliament, by Cabinet, by others to participate in this process, this process fully. I think it is extremely regrettable too that the medical service providers were not consulted. I find it difficult to understand why that would be the case. And I find it difficult to understand how third-party administrators and pre-funders who play an important role here were not introduced or into the CO process. Likewise, neither were the banks. So I think perhaps there was a question, what should we do? Well, from my perspective, if we want good legislation, there's a lot of good in this legislation, but if there are these key question marks about legislation, rather take a step back and do a proper socioeconomic impact assessment that could probably enhance the quality of this legislation and make it better fit for purpose. And maybe we can do that with regulation as well. But I do think it's essential to take the viewpoint of domestic workers, workers more broadly, employers, and medical service providers into account. And I think this process is helping it, but I think that's not quite what a socioeconomic impact assessment does. Honourable Dunshwa, you raised the question about the process of a CERA, and thank you for that, and your wisdom in this matter too, that of course it's gone through the Cabinet process. Unfortunately, I hope it wasn't a weakness in IWAG's approach to this. We didn't get to see the socioeconomic impact assessment. We really had to look for it. I had thought, and please correct me here, I thought that the socioeconomic impact assessment had to be published at the same time as the bill. I just didn't get to see it, and I know that, you know, domestic workers didn't get to see it. I think you heard today that Hospital Association of South Africa wasn't consulted, SAMA wasn't. And remember, the CS says who's going to be impacted, and unfortunately, this one doesn't tell you who is going to be impacted, and it doesn't consult those people who will be impacted. It also doesn't spell out the benefit of the proposed change as well at all, and it doesn't justify them. So I'm just asking for a good, solid process that does justice to our legislative democracy.
I may have missed you, Mr. Hugh. My question, that have you made a submission when the department has requested submissions to be made on the bill?
Chair, no.
Okay.
Interesting enough, I mean, IWAG was formed a couple of years ago, Chair, so we've been quite active and communicating with the fund. So thank you for your question. No, we were not around as an entity before then. Perfectly happy to make any submission, of course, but no, unfortunately, we didn't exist during those 2015. We were not in existence. I'm sorry.
No, sorry. I will respond to that after you've been responded to there's a follow-up question, Honorable Nonsal.
Thank you, Honorable Chair, and thanks, Mr. Hughes, for the responses. Just one follow-up question, Chair, is with regard to whether, for instance, Mr. Hughes has taken into account that issues relating to incorporation of the domestic workers relate to the outcomes of the Concord ruling with regard to that exclusion. Whether,
we are losing you, Honorable Nonsel.
For instance, have they taken into account as part of their submission that there is the necessity to respond to the Concord outcomes?
We have lost.
Point of I'm sorry? Yes, because I have a bad network.
We've lost the greater part of your follow-up question. Are you still around? No, Mr. Hugh, mine is now this process of the bill. It has started sometime last year when the department, the ministry through the department have submitted to the country. Invitations were circulated for people to comment, because that's what the department is to do, the ministry through the department, to comment on the, not talking about 2015, I'm talking about this bill now, this process, because after all what the department has done, responded to your concerns, it will then, the cabinet will take its process, and when that is done, it will then be sent to the office of the speaker to be then so that now it is in front of us. I'm not talking about 2015. I'm talking about these amendments that we are dealing with, because I would have thought that what you are commenting on in terms of the social impact assessment, you would have done that. I'm not saying you must not ask it now, but I think you should have done that when the written submissions were when the department has circulated invitations for every company, individual, or institutions to comment on the amendments. So that's why I don't know whether Mr. Honorable Nontsele is back.
Yes, Chair, can you hear me?
We can hear you. I hope you are not going to be affected by. Can you start again on your comment, on your follow-up question?
Thank you, Chair. Chair, the follow-up question is just a short one. Is whether, for instance, Mr. Hughes had taken into account the Concord outcomes with regard to the inclusion of domestic workers, so that when talking into the issue of their exclusion on the processes relating to the socio-economic impact assessment, you should factor that as well, because the Concord goes further to, in fact, to talk to the issues that he was talking to that relates to retrospectivity of some of the issues that relate to their working conditions. So I just wanted to get that clarity from him, if they have taken that into account.
Okay. Okay. Thank you, Mr. Nontsele, Honorable Nontsele. And are you done now? Thank you. Mr. Hugh?
Honourable, you've clarified your point for us. Thank you very much indeed in terms of participation. The only input that, IWAG has made is in this parliamentary process when your committee called for written submissions, public submissions, and we did so, not prior to that point in time. Okay. So I take your point extremely well. Thank you for the guidance and the counsel.
Honorable Nontsele's question.
Yes, Honorable, a very good question. I think that your point is extremely well made, and of course so is the Concords as well. I think, however, you will have seen some submissions, as far as I know, from the workers or SERI, for example, or domestic workers unions, arguing quite strongly for the retrospective application of benefits as well, and I suspect that's a process that is still going to play out. I was, from the IWAG perspective, saying circumstances have now changed. We now have 1 million new workers and employers. I think that this does, to the earlier questions, this does change how the challenges for the fund, the potential and the challenges to the fund. And wouldn't it be a good idea just to run some scenarios and to get some ideas about what that impact would be? Just logically, circumstances have changed very profoundly with domestic workers and their employers. If circumstances have changed so importantly, and in fact, we've got a new Comp-Easy system and so on, not a Umashluku system, wouldn't it be a good idea perhaps to run another socioeconomic impact assessment, taking those issues into account? Let's go back, perhaps look at domestic workers. How do they feel? Do they understand the impact? What might happen? What about medical service providers, SAMA, HASA? What about employers? What about banks? And also, what about these third-party administrators? It just seems to me that the SEER missed so many important stakeholders, and circumstances have changed so much that it would be a good idea, possibly a good idea, to go back and look at what those gaps are, see if we can get some data as to what the impact may be, see if we can quantify it, and that may be able to help us to produce a somewhat better bill that is more fit for purpose, particularly with regard to 43.4. That's my contention.
Mr. Hugh, thank you very much for the presentation and the passion that you have displayed in terms of your presentation. And we also want to sincerely apologize for the initial glitches. But yeah, I think in the light that there are no more questions of clarity, you are the last group for today, and because this is the last day for the oral submissions for COIDA. And thank you very much. I will request the hosts, when everybody is going to go out, but I would like to just have a word or two with the members of Parliament who are members of the Portfolio Committee. Can then everybody, including Mr. Hugh, be logged out? Because now I just want to deal with house rules in terms of our committee. But thank you very much, and thank you very much to everybody. Ms. Ndabeni and Mr. Ngobo, Wilds, can you please take everybody out? And I'm humbly requesting members to just be just a minute. Who's Danny Cohen? Who's Danny Cohen? Portia.
Hello, Chair.
Banu Danny Cohen.
It's one of the participants, ma'am.
Makapume. He must get out. Why is he still? Yes.
Okay, she's gone now.
She's gone. Relay. Please. Are they all out? Baphumile bonke Portia. Are we 16? In this 16, does it include the members it includes yourself, the department is fine?
I just wanna, ma'am, okay, I'll put